Hello, everyone. Welcome back to the Court of Random Opinion. We're here tonight because there's been a grave injustice served upon Laura Owens, who is wrongfully accused of faking a pregnancy. That's right. Wrongfully. What was the title of those Medium articles? I was going to make fun of it, but I can't now. Anyways, I thought that since we had such a biased and unfair court of appeals, maybe we should go to the court of public opinion. Yeah. Now I
In
can
my face.
You all. There you go.
Yeah,
What is that about?
Sorry, no one could hear you because I had you muted. It was like
I was just remarking about how there was balls in my face at the beginning of this stream.
I was aware
What
of
an
that. Yes.
appropriate way to. I know.
You need the breaking news music.
I don't have it. That was way worse though.
Pow chicka wow wow.
You know what you need is the Facebook freak out.
Lauren, what is the title of your stream?
I don't remember. Con artist Laura Owens. Hold on. Con artist Laura Owens loses scam appeal.
The title of my stream is Laura Owens and David Gingras lose their appeal. D's nuts.
Oh, you actually did. You actually did that. I thought that was a joke.
No, I was not fucking around. That's what we're doing today.
I feel like I should be shocked, but I'm not.
Mm.
Oh my gosh. Is that a monster? Yes.
Oh my god.
Actually.
My brother doesn't even believe I'm serious that I'm doing this.
There is so much going on right now. Who is Harmless Error?
That's me, but it's Dave. It's Gingras. I am David Gingras for the night. Hopefully he doesn't copyright me.
That's Patrick. That's Patrick.
Oh,
Guys.
is that Patrick with his CP viewing eye?
This is Gingras the day he lost the MATA complaint and got pulled over in the same day. Because fuck around and find out, you idiot.
Oh.
You got pulled over by the cops, right?
Yeah. He wasn't drinking, but apparently had time to take a selfie, which is some stupid behavior in and of itself.
Hey, I'm drinking Red Bull again, whatever that means.
I'm drinking his tears, honestly.
Oh man, I left my tear cup downstairs.
You gotta get it.
Yeah.
We are live, aren't we? Good.
We're live.
Yeah.
We're live. And I'm all dressed up for the occasion. I'm even wearing a shirt.
All right, let me pull up this
Like a dress shirt.
Let me pull up this website, which is where we got the appeal from. I mean, I also found it on Reddit, but hang on one second. So this website has pretty much everything you need. There we go. So you got there's Laura in general, which I'm sure is a novel. There's Clayton's case, Greg's case, Mike's case, and of course we know Greg. There was that recent hearing where she tried to. Well, she unfortunately successfully, I guess, renewed the order of protection she has against him for absolutely no reason whatsoever. She seems to think that she's going to get away with that again because he's not supposed to ever talk about her either, which is not a thing. That's not a thing. It's never
get away with. Oh, I know what you're talking about. Yeah, she ain't getting away with anything like that.
No. So that's the website we are getting this off of, and here is the actual appeal.
I was wondering how JFC got that so quick.
Because JFC has connections.
They're full of secrets.
I think JFC has a lot of people who are not involved in the case who are resourceful
and invested because of Gingerbread's untoward behavior.
I gotta say, this is absolutely definitely becoming a documentary now, but the JFC community in and of itself is just some of the smartest, coolest people I've met on the internet. I didn't think the internet existed for people like that. I thought the internet was only Gingras's, but I restored my faith in humanity. And not even because Laura is a lying bitch, just because the people in it are so smart and right in this case.
Could we just point out that David Gingras once made a YouTube video about how Omar is a California attorney. He's not even licensed in Arizona. And obviously 25 doesn't apply. And then it's I might not be licensed in Arizona, bitch, but how do I know the law better than you? How? Because it seems like this appellate opinion is exactly everything I said was going to happen way back in October.
We both said it.
We did both say it at the same time. You're on my show saying it. We did say that.
First time we talked.
Not only did you both say that, but a 3-judge panel in Tucson, which had no attachment to Phoenix, made the opinion, which means he can't say that, oh, they're biased because they were smitten by Clayton's celebrity or anything like that. No, the exact reason that Gingras wanted it to be in Tucson was because of the unbiased nature of that court would be. And
so I guess we have an unbiased document here,
And he wanted all the extra
guess
attention.
What? You don't need a license for critical thinking. Okay.
Thank you.
Well, I beg to differ. They were clearly biased because I, went to school at the University of Arizona in Tucson. Therefore, my cells died there, and my influence is somehow still controlling the minds of the court. And that is why this poor innocent, clearly been pregnant 40,000 times and totally didn't fake cancer woman was denied her appeal unjustly.
It's really unfortunate they were denied an oral appeal because I hear Laura is really good at that.
Or not so good at it because it didn't. Well, I will not be crass.
No teeth.
Could I just say? I want to say something. No. Could I just say something before we go all in on these two fucking people? I am so proud of Lauren Knighty. I remember a time when she was under attack from both of these fucking pieces of shit, where they were threatening her with various things, and I was getting like late night text messages from Lauren about, just her anxiety.
To tell people about those.
Oh, I know. And just she was so beside herself with like worry and anxiety because of the stupid threats that they were making. I was trying my best to try to keep it under wraps because, I'm an attorney and like, she was going through it. I just want to say that for where she was then, where she's at now, I'm so proud of Lauren and her hard work. I'm so proud to call her my friend. And I think that she should take a victory shot in honor of this very clear decision by the Arizona appellate courts. What do you think of that?
Red Bull. I'll drink some Red Bull. I'm not drinking anymore, though, remember?
Oh, Red Bull and not schnapps.
Nice.
Red Bull and I know. Fuck.
I left the weed downstairs.
A nice shot of Gatorade, and perhaps somebody should Instacart her some condoms.
I think I still have some left over from my visit with your dad. So we're good.
You know what? Maybe I will. I'm gonna send you something fun
she can use
that you'll get hopefully on stream.
Oh no!
Lauren's like, what? The look of fear on her face.
I don't know what to
challenge.
She's like, what?
It's cool, Lauren. It's from friends. You're safe.
Yeah, but
I think anyway.
They're from my friends. So it's a problem.
And Bruce, Brad, Schnitzel, Patrick, we've gotten to know each other over the course of, I was late to the party. I didn't even get involved until like May of last year, but you guys have all been on this case and talking about this case and sticking to your convictions and listening to reason and reading the law. And I want you guys all to feel good about the victory lap that we're going to take and about how we're going to shit on David Gingerbread and bury his legal career in real time.
It was so good having you join the case at that time, Omar, because a lot of us who had been following the case from the beginning, we were so into it and we were so entrenched in the day-to-day of like, okay, now there's this crazy filing, now there's that crazy, because that was when they were in the main case doing a lot of crazy filings, right? Yeah. And the thing was, it was so nice to have somebody come in, after there was a lot of foundation and just take a look at it with a fresh set of eyes. Okay. Just to give us the confidence, like, did we miss something? Are we off the rails here? Like,
yes.
Like, what is happening? So the first day we got to see some streams where you were just going through like, okay, I got an email from this guy. I got an email from Laura. Here's this court document. This tight email is freaking me out. I don't understand what's going on here in my life. Why am I what am I reading? Like, it was just so helpful to have that mental, like almost a reset. So, thanks.
I completely get that sentiment too, because there were times where there was stuff coming out from the Gingerbread camp where I was like, dude, am I fucking retarded? Like, why is he so confident about his position?
Yeah, but Omar, we talked about that word. You're not allowed to use it on the stream.
Am I mentally ill? I feel like I'm reading the law just fine, and he just seems to think some other thing applies. I don't understand. I remember having conversations with Patrick. It's like, dude, am I missing something? Like, did I miss something? Because I need to know if I missed something. I don't want to be like embarrassed and like go on with this. But no, we missed nothing.
We walked through every like step, like several different permutations to it, and we were like, no, but this conclusion is Rule 26 doesn't matter. I think the thing that I remember, like I can remember most specifically about this, was finding Clayton requesting fees in his complaint that day with you, and that's when you and I were like, "That's it."
Well, because Gingras was like, he made a video to tell me that Rule 25 didn't apply because of Rule 26, and I'm like, how? He said specifically because this was a paternity petition, and it wasn't because of this other thing, and it's not the right category, so therefore. And like, okay, David Gingras, but how come all of these like 27 different cases have awarded fees under Rule 25, and you're telling me that it shouldn't apply? And the appellate court has come in clutch, and they said, well, she was appropriately awarded under Rule 25, and what's more, the judge had to award sanctions under 25 because it was specifically requested, and they made certain findings. I'm getting into the preview of what the appellate court's going to say, but that was the gist. So we have been not exonerated. What's the word? We have been endorsed.
Should never be exonerated
by the appellate courts. The appellate courts have said, yeah, of course, obviously that's the case. And David Gingerbread he's not the R word. He's
vindicated is the word you're looking for.
He's a bad lawyer. He's a 1L level caliber lawyer. Which is why I call him 1L.
I think that he's on his way out. I think he knows he's on his way out, and this is kind of his closing salvo to extort as much money as he can from LO. Convincing her.
Is he still has an active case in Florida, so in federal court.
I follow that docket, and it's a pissing match. It's nothing interesting.
Damn.
I've never seen a litigation involving Gingerbread that was not a pissing match. Everything is dick measuring to this guy.
No, everything is like the race to the motion to dismiss, the race to summary judgment, then the race to 5 years of discovery. Like, it's not complicated. He's just like a low T lawyer.
Low T lawyer is a perfect way to put it. He's like one of these lawyers. He's been in the game for so long, and he's so used to people caving into his load of bullshit that he just thought he was going to do that with the entire community supporting Clayton Echard. I'm not even going to call it the JFC community. All of you guys, Schnitzel Ninja, Patrick, Bruce, Brad, Lauren, Dave, Neal, Megan Fox, that were in on this case. Gillespie, Mike Maricini, Clayton Echard, all of these people that have been affected by this case that were wondering, am I the crazy one? I don't understand how people could just like say these lies and get away with it. Well, they haven't gotten away with it. And the Arizona appellate courts have spoken, and they have declared Laura Owens a fucking liar. And David Gingras a substandard attorney. And we should all take a good long piss on David Gingerbread's grave. How about that?
Cheers.
A good steaming piss. Cheers to that.
I drink all of this on Plaid, so it's going to have to come out.
I know it may not be safe for me to be on the stream now because I just drank everything for Plaid.
Chat, if you got a drink, even if you don't drink, just cheers us.
And also, it's not just that he did a bad job with the case. It's that he was rude along the way. He didn't have to do that. Yeah. The entire community of just average random people, arbitrary people in the community following this case, okay, trying to see due process, trying to understand what is happening with this case. How can this happen to someone? How can you go file a paternity case with basically no proof of pregnancy or paternity clinically? How can you do that? And he turns around and calls them a cult, calls them total fucking psychotic assholes, tells Dave Neal he's going to be homeless in a year.
Yeah, fuck that guy.
This guy was unbelievably rude.
Damn it.
He was unbelievably rude, and we will not stand for it. He's wrong. He was wrong. He is wrong, and he fucking lost.
Yeah, he lost and royally lost. Not even
he deserved to lose,
bro.
He was a rude motherfucker, and he lost.
I really thought they were going to have at least oral arguments. They didn't want to waste their time. Like, oral arguments for what? You lost, bitch. There's no legal merit to your argument. We don't need oral arguments. You lost. If that's what you're running on, you lost.
It was taking so long. That's what I was thinking. I was like, there's just no way. Like, maybe they just rule without it and deny it in the ruling.
I wonder if that was because of the procedural issue they were having that I didn't really get into.
I feel like it could even be like Mata's ruling. That like the way, because from what I understand, they are not typically that long and that detailed.
Yeah.
And I think she did it for a reason. And I think she knew it was going to be appealed. And the appellate court obviously they got that as evidence, right? Like part of the documentation.
Right.
I feel like, I mean, I don't know if I was just optimistic, but I felt like what he was saying was just such fucking bullshit that there was no way in my mind that they were going to win that appeal.
Well, in my mind either. And I was even and I don't want to say insecure. I was questioning, like, why do I feel like this is so simple? I must be missing something. Is there
Like, there's
any
got to be
merit
a
whatsoever?
technicality we don't know, or like a 12-day rule we don't know. But you know, I researched Rule 11, which I don't think he knows Arizona Rule 11. I researched Arizona Rule 11, which, I mean, just the general way of lawyering, just for anyone who's not a lawyer, this is how I do it. I always like assume that the federal law is probably like the most general. And then as you get into the state law, it's basically the same thing, but a little looser. And
that's how I approach it too.
And I'm okay with that. So like and then what I learned through this case is that family law has rules of civil procedure as well. And they're just even looser than the civil.
Yep. Yeah, which was my conundrum with him. It's like, why do you think that this is going to work the same way as federal Rule 11 in civil litigation, where they're arguing breach of contract cases? Dude, it's family fucking law. Like, there's
the minimum amount in controversy is 75 G's. Like, they have to have strict procedure. Like, it's a lot of money to get in the
Jennifer, to answer Jennifer Woodward, I believe it's a serious dunk on Gingerbread, because at the very, this was, I don't know how many high profile cases they get, but there was no reason not to have an oral argument. Most appeals require an oral argument because there's a legitimate question of law. But the fact that they're denying oral arguments is that there's not a legitimate question of law. It's to say that his argument is so legally absurd. If that's what you're going to come here to argue, then we don't need to hear it. We're done. Denied. That's what it basically states.
What the appellate court basically said is, why do we want to get David Gingras to go stand in front of us and say, but Rule 26, and have that be the response to everything? Like, there's no reason for that.
It's just not legally meritorious. There's no reason to entertain that argument because it's so obviously wrong. And so I don't even know if he has a misunderstanding of law. I feel like he's gotten used to bullying other inexperienced attorneys, perhaps. Maybe he's just gotten too used to bullying people in his regular practice. I don't know. But this idea that he was going to just bully everybody into thinking that Rule 26 was superior to Rule 25 somehow, in the face of hundreds of cases that said otherwise, speaks to his naivete, for one. I don't want to say his inexperience, is his over-experience and his overconfidence in his ability to walk into a courtroom and intimidate folks. Because I was never intimidated by Gingerbread. I don't think any of you were intimidated by Gingerbread.
Never.
The appellate
a little
courts were
bit,
not.
in my opinion.
I don't know. I felt weird for a while.
Well, for other reasons, though. For other reasons. But I was never impressed with his knowledge of the law. I thought that he had a warped sense of law that was based on bullshit. Wait.
What do you call a doctor who finished at the bottom of his class?
A doctor.
A doctor. That's exactly what fucking kind of lawyer he is.
Yes.
But he passed the California bar and the Arizona bar.
He's a doctor.
The Arizona
in both
bar
states?
is not that fucking hard, dude.
He's got a doctorate now in losing cases.
He's going to lose his license, I think, is what's going to happen next. And you know what? I think it is worth noting that we should place some significance in the fact that the appellate court is denying his oral arguments with the knowledge that he is currently under investigation with the Arizona State Bar for multiple bar complaints. I think they've probably taken that into account with everything else. I don't know if they're allowed to do that. Well, they're not allowed to do that. They got to go by the record. Yeah, but I think that it bears noting that he is currently under investigation for multiple violations of the ethics rules in the state of Arizona, and they are not allowing this guy an oral audience because his arguments are stupid.
He got in trouble with the bar because of stupid arguments.
You can get in trouble with the bar for stupid arguments, especially ones that have zero merits. I mean, it's not a common thing, but as far as ineffective assistance of counsel go, look, as an attorney, you have this license. You're putting yourself out there like you know the law, and to the extent that your performance is so substandard that the bar starts questioning about whether or not you should be a lawyer. I've seen that happen to people before.
Well, his stupid arguments resulted in a bar complaint from a judge.
Which is
that's
fucking
not
hard
a common
to do.
Occurrence in life.
It's really hard to do. And so
I just had to check to make sure there was no new Medium article. I'm sure she's still sending voice notes to Greg from Block Numbers. So she, we'll probably get to that later.
Hey, Lauren.
Oh my gosh.
What's up?
So my mom is listening and she has no idea what we're talking about. So for your new listeners, can you give us she already knows it's going to be bad. I warned her.
Could I give the synopsis? Could I give it?
No, you need to shut up. What?
Oh, okay. It's not my channel. It's not my channel, but yes, Mom.
There's no such thing as a 30-second recap for this case.
Yeah.
No,
there really isn't.
Patrick, go ahead.
Oh, Omar can do it. I don't know how to do it.
Okay.
No, I mean, what was the question?
She wants.
Will you give your new audience listeners a recap? And Omar said he'd do it.
Yes. Wild cunt. Pretended to be pregnant after.
What did you call me?
My mom. What the fuck, bro?
It's my mom.
Well, you said she knew it was going to be bad. Okay.
She's sitting in the living room with my dad, like probably knitting a sweater, and you just yelled "cunt" into her living room.
Hello,
Lauren.
So sorry,
have you no sense of decorum? Okay, this is what happened.
No, hey, you Mister, shut your mouth. I muted him. I can't hear you, Omar. Wait, hold on. Okay, so royally wild word that means vagina. Mr. and Mrs. Patrick in your living room. Wild lady, wild lady part, faked twin pregnancy after a blowjob, went on plane, disturbed the general public, somehow has not yet been killed, comes back, fakes cancer, continues to drag guy through the mud, and then she repeats that times 3, and then she did it to The Bachelor, and then there was a whole court case, and then she was like, I'm appealing this decision because I totally made those doctor's appointments, and then now you're listening to me not really explain this very well in your living room. All right, I'm going to unmute my friend Omar here so he can do a better job.
All right, so here's the synopsis. This is what I would say. Young lady meets a pseudo-celebrity gentleman named Clayton Echard. She becomes infatuated with him and tracks him under the guise of performing some kind of a real estate deal. In the course of that, they have a one-night stand that involves oral copulation, but no sexual penetration. And on the strength of oral copulation, she claims to have gotten pregnant. Clayton Echard's like, there's no effing way you were pregnant.
Omar,
like,
for the class, could you please explain copulation?
Sex, oral sex. She claims through a blowjob she was impregnated with twins. And Clayton Echard says, like hell you were. And she's like, no, it's true. I will take a pregnancy test right in front of you. She proceeds to take a piss onto this pregnancy stick that confirms pregnancy. Turns out, we come to find out through litigation and discovery that she faked a pregnancy test.
The stores never really came.
An ultrasound and elevated artificially her HCG levels to make it look like she was pregnant, and proceeded to try to lead him on into thinking that she was pregnant with twins, and then said specifically this: look, if you date me, I will get an abortion, but if you don't, I will have these children and you will be the father and I will come after you for child support. Proceeds to file a paternity petition against Clayton Echard for the purpose of initiating a parenting plan and some form of child support. A few months pass by. Her elevated HCG levels that were the result of some other condition could no longer could no longer hold. She appears in court with what appeared to be a artificial pregnancy belly. Everybody announces it. At some point in November, she brings the petition in August. At some point in November, she announces, you know what? I was just kidding. Or not, I was just kidding. I had a miscarriage in December. I had a miscarriage and I want to dismiss the whole thing. And Clayton Echard says, bullshit, you're going to dismiss it because I know for a fact you were faking this shit because there's no way you were pregnant off of a blowjob. And she proceeds to try to get it dismissed. David Gingras enters the picture at around March of 2024. And then they have an entire trial where they litigate the issue of basically whether or not she was ever really legitimately pregnant. They litigate it. They have competing experts come in, and they explain that her elevated HCG levels could have been because of a number of different factors, one of which would have been pregnancy, but like a dozen others that would have been because of some other reason. It come to find out that the ultrasound that she provided to the court was faked, manufactured. She took somebody else's ultrasound doctored it and made it look like it was hers. And that was the only evidence that Clayton Echard ever saw that she was actually pregnant. And she admitted that on the stand, and that was the whole thing. So Clayton Echard asks for sanctions. The first thing he did when he answered her paternity petition was, I want sanctions because she's lying. And he said that back in August of 2023. And so they have a whole trial on the matter. During cross-examination, Laura Owens crumbles. She not only states that, look, I made multiple appointments. I let Clayton Echard know that I was going to have these ultrasound appointments, but I didn't want him to know where they were going to be because I was afraid of him, while at the same time trying to get him to actively date him. The incentive to dating Laura Owens was that her vagina was so tight that if he would only feel the four walls of her vagina, that he would change her mind about her. And Echard was like, number one, it was admission. It was an admission that he had never felt the four walls of her vagina. Second, if she was pregnant, then it would have had to have been under the most unlikely of circumstances, which would have resulted, it would have been the first documented case in American history, perhaps world history, where a woman was found to be pregnant legitimately as a result of a blowjob. And so we continue
Other than the Virgin Mary.
Other than the Virgin Mary, exactly. And so we
I'm
continue.
still unclear on that one as well, but go ahead.
The trial commences. The judge makes her decision. They rule against Laura Owens. Laura Owens is found to be a liar for a number of different reasons that I'm not going to do justice in this 90-second synopsis. Clayton Echard rejoices over the victory. David Gingras convinces Laura Owens that she has an appeal that she could launch, but he would have to, well, I don't know what the arrangements were, but he convinces her to file this appeal. They do file this appeal. He starts a frickin' YouTube channel extolling the virtues of his appellate arguments. And he goes into this whole battle with me personally about the legal merits about his appellate arguments. He goes on to debate Reality Steve. Who's the judge from Harvard? What was her name?
Rachel Juarez, yeah.
Rachel Juarez.
She commented, I don't know if they were ever going to do a thing, but
Came
ultimately,
for every single person on this stream right now.
Yeah, he never actually gives an actual interview to argue the merits of anything. He just says that we will see when the appellate decision comes down. And now it has come down. And the appellate courts have said that David Gingras, you were fucking wrong. You were full of shit. Appellate motion denied. Not only will you pay the original fees that were awarded, but now you're going to pay these appellate fees. And we will get into that coming up next.
I want to know what the total.
Oh my god!
No, please, no, not again. Wait. Let's not forget about this.
Dang.
I hope nobody paid $10 a month for that, since there are no episodes.
Truth Circle.
Does this thing still exist?
The tight vagina circle.
Apparently it does.
Yeah.
Oh my god.
Golly.
Unlike the twins.
For the ladies on stream, could I ask you guys how many times you've ever advertised the tightness of your nether regions
Only when it was inappropriate and kind
as
of
a
awkward.
bonus for the perks of dating you specifically?
I
Argue that.
didn't need that as a perk. I have so many other perks. I didn't even need to mention it.
It's a given. It's a given.
I mean,
Never
geez,
mind
Omar,
about the tightness of my vagina. Watch all of my other skills.
I have dentures.
what's wrong with you, Omar?
That
I'm
thing
getting those
must look
DMs
like
right
a-
now. I mean,
That thing
come
must
on.
look like a blown out windsock if she had to advertise it.
Oh, I'm too old for them kind of texts, man. I don't get those texts anymore.
Oh yeah, Gingras called me an old white guy.
What?
That was fun.
But you are an old white guy, but he's older than you. He's older and whiter than you, Bruce.
But he
Bruce isn't
didn't.
old.
Well,
He's
he
like-
said he said he didn't know who I was, but then he said I was old and white.
Well, he knows you now. And if he didn't know you before, and let me introduce
Well,
you to
no.
Bruce.
How do you
from
say you don't know
Oregon.
who someone is and then call them old and white?
Right.
It's
It's,
a
like
it's a
you
non
obviously know
sequitur.
who they are.
It's a logical error. It's
Could
a
I just point out the
category error.
fallacy of his argument is that he's older and whiter than you?
I mean, sure.
I mean, and you're pretty white, but he's whiter somehow.
You know.
You meant to say pretty and white.
Pretty and white.
Oh my god!
Yeah,
Remember his
he didn't go
legs
to-
on his cruise? Those were some white
Oh
legs.
yeah. He didn't go to high
Oh.
school in South Central like I did.
Guys, what's the
LA?
what's the export
Like Southgate?
South Central, Wisconsin.
What?
Oh,
Oh,
shit.
Yeah.
So-
Wait, was that the Reddit lawyer?
No, the idea is that Ex parte Young is a court case where
okay.
suing a federal official in your case.
Right.
And he's saying that it provides a legal avenue for him to try and go after Mata and the bar guy to get discovery that would ultimately prove what he alleges is the conspiracy between Mata and her father.
Good luck with that one.
Did someone ask about that
Yeah.
in the chat?
Yes.
Mhm.
No.
The umbrella guy. The umbrella
sorry,
guy was
Cecil,
so
you were
happy
gonna
to
say
hear the
something?
news.
Oh, I was gonna ask. It was kind of a different tangent here. I was gonna ask, do we think that Judge Mata would take any legal action against Gingras?
Nah, I don't think that she will. Just because for what, man? Like for
Yeah,
what
not
kind of
worth her
gain?
time.
She filed the bar complaint. That's the best
Yeah.
that she could have done.
Yeah, I don't think she's looking for monetary gain from gingerbread over here.
No, but maybe even a ruling, like so something's in.
She probably feels vindicated because he was accusing her of a lot of things, and the judge said, the appellate court said, no, fuck off with all of that.
And the ruling too, is also going to be from the bar. You know, she can still get that ruling. That
Mhm.
would vindicate her rights as the
Yeah.
victim of him.
I mean, her active work is done.
Mhm.
And
So
do we think he's going to take it to the Supreme Court?
that's a good question.
He could
I don't
try.
think
Do you think they're going to pick it up though? Why would they pick up an appellate argument that failed and didn't even make it to oral argument in Arizona? They're going to say, fuck off with
They
all
would
of
kick
that.
this out of their queue faster than
Yeah.
yeah.
anything else I can think of.
And he doesn't have the right to do that either. Like, he's been denied twice, so the court would have to take it. Choose to accept it. And the appeals court, you have the right to appeal.
They'll accept it, or I'm calling Interpol.
Now, Omar, here's the question. Does Firm Woodnick need to wait for him to, or for this appeal to end and him to not appeal? Or is there some sort of flag that says this whole thing is done?
Well,
Or-
right now there's nothing pending. So until he files some other action, then this case is over.
Well,
And they can
no,
start
And they go
collecting
about
the
trying to collect attorney's fees.
Yeah.
and
Yeah.
costs.
there
My
probably is
assumption
an
was
appellate order. There
if-
probably is an appellate time frame that, you know, if you are going to seek cert, which is if you are going to seek a hearing before the Supreme Court, you have to do it within XYZ days.
Okay, so there's
So
a
the
timer
appellate
that will
window is open.
expire.
Yes.
Because my assumption is if Firm Woodnick wants to file any bar complaints, they would want to wait for everything to be over before they did that.
That's a good call.
Yes,
Yeah.
I think that's accurate.
I think if they were Gingras, they would file it a day before, you know, the ruling was required. Or
I feel like if he were to try to bring this to the Supreme Court, it's the equivalent of trying to take like your traffic ticket to the Supreme Court. For what? What legal purpose are we advancing here, sir? Fuck off
So-
with all of that.
Here's
Remember, he
the
said to Laura, he goes, this case is more important than you. It's gonna be around for 100 years. Like, bro, you couldn't make 5 YouTube videos. The fuck are you talking about?
Yeah, I mean, if you don't even
Patrick,
get oral
you're using
arguments,
that
man.
language in your mother's living room.
Well, Patrick
yeah.
might
I think
be
I
on
went
a
to that.
gummy.
I
Leave
mean,
Patrick alone.
This case could get to the
Write it
fundamental
out.
right, of every American and every Greenlander, I guess, to bring a family court case to say you're pregnant with no evidence. Right?
But the appellate issue would be whether or not Rule
like a
26
constitutional.
Supersedes Rule 25, if mentioned ever in the litigation. Which the obvious answer to that is no. So there is no family law rights that would benefit anybody other than Gingras' warped idea of the law that if you ever invoke Rule 26, it's the equivalent of Rule 11 somehow, and any kind of other request under other avenues of law is invalidated, which is fundamentally stupid. So how about that?
There's no reason anyone would want to take these broad family law rules from Arizona domain and bring it up to the federal level. There's no way, right?
No, I mean,
It makes no sense.
Well, here's the thing. The common sense ruling is that if you ever ask for sanctions under any law that would warrant sanctions, it should be heard on its merits. What Gingras was effectively arguing was, or ineffectively arguing was, because she implicated Rule 26, or he implicated Rule 26, then all of the other requests for sanctions are invalidated, which is dumb. It didn't make sense to me back then, and it makes less sense to me now. And now that the appellate court has said, yeah, we don't have to have an argument about this, it tells me that David
It's not even
Gingras
worth
is
thinking about.
yeah, it's retarded. It's not retarded. What's the word? What's
Yeah,
the
I know.
You're gonna get me in trouble with YouTube again.
It is
There's no motivation.
preposterous. It is preposterous. How
There's
about
no
that?
motivation for the feds to do
Sorry,
some
guys.
sort of umbrella
Laura's
thing.
getting a haircut because this is
Yeah.
awful.
I
No.
agree with you, Omar, that that is what this case stands for. But I'm curious, like, is this going to be a published case?
It is not.
For what? It's not advancing. It's not changing any law.
It says
Well,
it does not create legal precedent and may not be cited except as authorized by applicable rules, not for publication.
Well, that's what it
Okay.
says now. But like, would it ever
Well-
become published because it's advancing some new understanding of the law? What we've already understood about the law is if you raise an issue of sanctions under any body of law, then it should be heard on its own merits. There's specific rules that apply to specific statutes. And just because you invoke one rule, it doesn't supersede all of the others. We already know that. We don't have to like advance the discussion somehow.
The reason I was asking is because Laura in her Medium post was talking about the precedent that a denial of her appeal would set. And I knew
That's
she was
because-
wrong then, but
That's
I just,
because
She had really been
Gingerbread was
pregnant.
telling her that shit, and he was wrong. He's been telling her like the London Bridge for months now, and he's been convincing her that she has an argument. And we've been trying to tell her that her argument is stupid, and not her argument. Gingras' argument was dumb, and now we have confirmation. His argument is preposterous. It's not the R word. It's preposterous.
There's no precedent. If you get a speeding ticket, it's not, and you have to pay the speeding ticket. It's not like that's some sort of amazingly new precedent or something.
Yeah.
well, I
It's
think the
just like-
precedent could be that, if you can go to like sue someone for paternity with a positive HCG test only, I think that would be the precedent.
Yeah,
Totally.
Well,
I totally missed what you said. What were you saying?
Well, the precedent would be if she won, right? When she filed the lawsuit, all she had in her hand, the only medical evidence that she had on hand was the most compelling was a blood draw with a positive HCG result. So
Well,
in terms of
if she
precedent,
won,
yeah.
then what would happen is this. If you ever invoke Rule 26 in Arizona Family Court, it supersedes all other requests for sanctions. And the rules governing Rule 26 would control. And if non-compliance with those rules would mean that any other request for sanctions that didn't follow those specific rules would fail. That is what Gingras was arguing.
Right, that was the appeal ground. So it wouldn't have anything to do with the HCG test.
well,
Just-
in the response to the appeal, I thought that they talked about how weird it would be if what they were arguing was correct. Is that right? Is my memory right?
Yeah, magic words.
Yeah. I mean,
Right.
it would sort of do this weird, if you think about set theory, it would create this set for cases that just doesn't make any sense.
Vada Kedavra in my case.
Yeah.
What the fuck was that?
Well,
If you know,
Oh
you know,
my
Omar.
God.
Lauren is showing you her O face.
you have to actually read. You have to actually read the court documents.
I also want to
Shibby-
give. I want to give a shout out. Oh my God.
God.
I want to give a shout out to Marcus Reisinger, the
Yeah,
appeals
That was his name. Yeah.
lawyer. Yeah, for Woodnick, Team Woodnick.
Yeah,
so
because I
Clayton.
think he explained exactly what you guys are talking about right now very well in his filings.
Should we get into the actual document and like
I was going to say
officially dunk on him?
before we do that, going back to the will he or won't he push to the Supreme Court. If we think about this from Laura's perspective, according to Gingras, he was paid for the work that was done for the evidentiary hearing. And he said he would do the appeal work pro bono. And now Laura would ask her attorney, I want you to take it to the Supreme Court because there ain't no way in hell I want to pay $150,000 plus probably another $60,000 plus for this appeal work.
Yeah, but Echard's attorneys don't have to work pro bono. If he wants to do that, good for him. But they get to collect their attorney fees. And now that we've had to
but
go
they're
through this
not
whole
going
appeal and loss.
to. She's going to claim bankruptcy. I'm telling you right now. I've been saying it for months.
Yeah,
And
I
they're
mean,
not
I
gonna
don't-
see a penny.
They're probably not going to collect anything from her, but that it doesn't foreclose on the judgment just because Gingras
sure.
wanted to work for free.
Yeah, but like Woodnick is out like what $150,000, $200,000 just for this case alone, and that's on
Yeah.
top
Probably.
of Greg Gillespie's
What's everyone
case.
doing?
I don't know.
I would think 300.
She's going full
I think
gremlin.
300. I
Conceited
really
gremlin
hope
over
Rich
here.
Lieberman asks Ron Owens about the judgment in his interview.
Why has my face got a penis on it? And then that's Lauren's like avatar.
That's a whole other.
There's
Why
no
is your
way.
face on my penis?
There's no way Jan is
There's no
going to
chance.
allow Ron to go on
No.
any podcast or do
Look-
any
Oh, yeah.
interview.
Here's
That's
the thing.
over.
If you have a bunch of medical bills and you have those documents, all you have to do is scan them and show them. Do your GoFundMe and then scan and show the receipts that show you paid those medical bills. This is trivial work.
Yeah.
Anybody can do that. It's dead simple. It's the simplest thing in the world to do. And of course, they're never going to do that.
Mm-mm.
I
Think
did
about
a,
that.
I
Think
did a
about that.
yard-
It's the easiest thing in the world to do.
We
You,
lose
you
Omar.
have a bill,
Yeah, where's
you
Omar?
do a GoFundMe, you have a receipt, and you show you paid for the bill. Those are the three simplest steps any moron on this planet could do. And they won't do it. Come on.
I did a what's it called, yard sale, and I donated 10% of it to my brother because his family lost their house in the hurricane. And you know what I did? I took a picture of him holding a $50 bill, like the end. And
Mhm.
they're gonna be like, it's a violation of my privacy. Like, no, you invited us in, and I think that's like what this family fundamentally doesn't get is like, you filed a public court case, like,
And put
you
your
fought
Dropbox on
this.
Reddit.
And you
Yeah,
made
you
and you,
showed
and you
us-
like advertised it on the Sun.
You showed us your like mildly compacted colon, like, and farted on a recorded phone call.
Oh, I keep forgetting about that.
Who did
Oh,
that?
yeah,
That was
never.
Lauren.
He's
Never.
full of
Laura-
shit.
Laura did with Brett from Ravgen.
Laura
No.
farted on camera?
Yes. No phone call.
It's on a recording.
Oh,
The
my
one that
God.
she about the Ravgen call that she posted. Or how did that get out?
Get with a program. Oh yeah, exactly. Bye. You don't know
lost-
that?
We
Get out
lost
of
Taylor.
here.
Yeah, but I don't, none of us ever knew that until Patrick pointed it out one day. He was like, I don't know. We were going around saying something. He was like, oh yeah, the farting on the call.
I think those calls were originally in the Dropbox, right?
Yeah.
Were they?
Yep.
Okay.
And
Yeah.
Patrick, because he has to go jogging with his, high-powered,
Studio
earphones
headphones.
with super audio quality.
Jesus.
They almost
hear
knocked
it.
me backwards. I could like feel the wind.
I don't want to feel anybody's ass wind, let alone or Owens.
Oh
mean-
my god!
Oh,
All right, and a Friday. Oh, have a great weekend, Laura and David. Like that couldn't have happened to some nicer people.
That's
I
the
don't know,
thing
man.
that
couldn't have happened to more
no.
deserving people.
For all the
Like,
Medium articles and all the bluster, that is the thing that I always come back to that they never explain. How do you do all these RabGen tests and you never prove paternity? It's just such a it's so blatant.
Now, the interesting thing I remember is that David Gingras on X was saying that he has.
Hold on. Sorry.
He supposedly has evidence because everyone was asking, well, why don't you just go get the Planned Parenthood ultrasound and prove it? Because it would be the easiest thing to prove and then show that your client isn't lying. And he's like, well, I can't do that because privacy, this, that, or the other thing. But it'll come out or something along those lines. And
Did he
it's
actually
like,
say that?
yeah, he's like, I have this stuff, but I can't do it right now. And it's like, dude, if you had it, you would release it. Like,
Absolutely.
it is the easiest thing.
And they'd
You know
rub it
what
in
I feel-
people's faces.
yeah,
Be like,
Like,
yeah,
we
look what I
should,
have.
That's
yeah,
been
I
the
was
fundamental
waiting for that.
problem with the petitioner's case the entire time from beginning to end is show, don't tell. Their entire case is tell. Trust me, bro. I was pregnant. Trust me, bro. I didn't have sex with anybody but Clayton. Trust
I
me,
believe
bro.
you, Bruce.
I went to the Planned Parenthood. Trust me, bro. No, that's not how science works. That's not how logic and reason work.
Yes, it is. Trust me, bro.
Hey, trust me, bro. Just touch it a little bit. Just a little.
Exactly.
I don't know what you do with your bros, but all right, hang on. Let me pull up. Let me
boy.
pull up this. We should start getting into this documents because it's
Before
been
we get too far
45
gone.
minutes. We're past there. I started.
Do you have any
this.
super chats before
You're-
we start?
Your delivery is coming in 10 to 15 minutes, by the way, so you're gonna have to step away then.
That's fine. No problem. Hang on. Let me go through these real quick. Cat Lady Ballerina, thank you for the $2. Ain't no party like a denied appeal after party.
Hey,
Just Jay Hip, thank you for the $2. Love me, Lauren. Love you back, Jay. Thank you. Kathleen, thank you for the $2. Sam,
Yeah, I'm going all out today because it's just me. Hey, where did everybody go?
We're here.
I'm here.
Oh, everybody went silent.
wait, Lauren's
So-
muted then.
Oh, Lauren muted herself.
fuck, I've been talking for a long time. All right.
Oh.
Okay, I'm gonna start over. Cat Lady, thank you for the $2. Just Jay, thank you for the $2. Love you back. Kathleen, thank you for the $2. Sarah, thank you for the $5. I read all your comments, but you couldn't hear me. Cat Lady, thank you for the $2. Tired, Rule 26, Wired, Rule 25. I don't know if any of these super chats are like, they might not even be on my channel because I don't know how the multicast works, but I'm just going to read them anyways. Pretend
Yo,
Judge,
I don't know.
thank you for the membership. Cat Lady, thank you for the 2. To be fair, I am actually a totally psychotic asshole. That's true. No, you're good. Snow Wonder, thank you for the membership. We got Donna Miano, thank you for the 5. Great job to all the group and congrats to the winners. Dan Mueller, thank you for the 10. Let's get Lauren to 15K subscribers. Hey, we're close. We're like 50 away, I think. Special KL, thank you for the 5. Great job on all your hard work in this case and being classy. Never. But thank you for the $5.
We yelled cunts shortly after that.
Squinty Bubbles, thank you for the membership and the 5 quarter random opinion memberships. I appreciate that. I'll have to do a little members only thing this weekend. Rainy Day Sprite, thank you for the 2. Can't stay awake even though I'm supposedly woke. All right. Loud Little Ducky, thank you for the 2. Let's reach this goal for Laura Owens losing. Steph, thanks for the 2. Props to the 18. Kirsten, thank you for the 2. I think, oh yeah, I got another one from Kirsten for 2. I don't know. Maybe the other one was for someone else. I'm not sure, but thank you. Aquinetta F, thank you for the 2. It's a party. It is a party. And Tiffany, thank you for the 2. It's been a wild ride. Yep. All right. Let's see.
Lauren, did you see my picture?
I did. Sorry, I was trying to pull that up, and then how do I make you here instead of me?
I don't know.
Click on her.
Click
Oh,
on.
there it is.
Hey, whose face is that?
So that's
Mine.
Lauren with a Snapchat filter on.
My
Oh, my.
God.
I
didn't
do
know
that to
Saddam
myself.
Hussein was back from the grave.
Oh, I have Omar like that too, and I think I have Brad with that filter on.
Oh
as well.
no.
This is why I try to avoid Snapchat.
I forgot these last
Jeez.
few. Hang on. Stacy MH, thank you for the 2. Gingerbread went private on Twitter.
Did he though, or did he just block people?
He
I don't
did.
know.
He went
He went private.
protected.
Yeah.
Oh, really?
Yeah.
Well, congrats.
To David
You know-
Eddo, thank you for the 7. Loving the live stream for the first time
Yeah.
hearing about this case. Thank you for joining us. And
That's the other thing to
Kirsten,
keep
thank you
in
for the
mind.
50. Appreciate it.
Not only has he lost, filing after filing and ruling after ruling, he completely lost the PR battle in the public domain.
Thanks again, Kirsten. All right. Could I get, let's see, where do we start here? Right here? Okay. Can I get Snithel Ninja to read the first paragraph while I fix my lighting real quick?
Ooh.
In Brianna Banks' voice.
Oh,
No, please, no, please.
That's
No.
what.
That is so irritating. Please, no.
Okay.
Okay, thank you.
It doesn't
In-
even sound like porn to me. It sounds like Tiny Toons Adventures.
I'm gonna grab another.
That's porn to some people.
I'm gonna get a Red Bull too.
Oh,
So
God.
I'll be right back. I'll be right back.
All
Do
right.
it.
To each their own.
Okay. Oh, okay.
What are we doing?
In this paternity action, Laura Owens appeals the trial court's award of attorney fees and costs in favor of Clayton Echard. She argues that Echard's failure to comply with the safe harbor requirements of Rule 26 precluded sua sponte sanctions under any authority that the
It
amount
was
of
Sponte. Oh, I like that. It was like all French.
it's Italian or Latin rather.
It is Latin.
Argues
mistake.
which all languages are derived from which all languages are derived, argues the court committed structural error by conducting its own post-trial investigation into the facts of the case. For the following reasons, we affirm. I should say like romance languages.
Oh, they're
Anyway.
going to talk about
That sounds
every
more right.
issue. Let's go.
Yes, factual and procedural background. 2, we view the facts in the light most favorable to sustaining the trial court's findings and orders. Hefner versus Hefner, 2019. In May 2023, Owens and Echard had an intimate encounter. Shortly thereafter, Owens learned she was pregnant. Did she? Alleged she was pregnant. In August, I'll correct that for them. In August 2023, she filed a paternity petition alleging Echard was the father. Echard denied paternity. In December 2023, the case was placed on the administrative dismissal calendar for lack of prosecution. Echard moved to extend the dismissal date, arguing that he was entitled to an adjudication finding of non-paternity. He also requested an evidentiary hearing on the paternity issue, attorney fees, and Rule 26 sanctions. In response, Owens informed the trial court she was no longer pregnant and thus there was nothing left to adjudicate, and this case should be dismissed.
Not now pregnant. I'll correct that for them.
Yeah. She simultaneously moved to dismiss the case with prejudice. Echard opposed. Echard then separately moved for Rule 26 sanctions, arguing Owens' petition was filed for an improper purpose. Her motion to dismiss was unsupported by existing law, and her factual
Contentions.
Oh, thank you. Oh my God, my brain. Contentions were not supported by evidence and did not become supported by evidence after investigation and discovery. Owens responded that Echard had not complied with Rule 26 requirements because he did not provide her with written notice of specific conduct alleged to have violated Rule 26, and that she was therefore not afforded time to cure any alleged deficiencies. Echard eventually moved to withdraw his Rule 26 motion, arguing that
Lauren.
The ghost of Lauren.
Oh boy.
There was no reason to participate in the pointless litigation over this issue, notwithstanding his disagreement with Owens' legal positions on Rule 26, because Rule 26 was not the substantive pleading basis for his claims for attorney fees and sanctions.
Was that a little shade by the court right there?
Yeah. It feels a little shady.
Yeah, like yeah, of course Woodnick didn't want to fuck around with you because you're an idiot.
The court extended the dismissal deadline, denied Owens' motion to dismiss, and set an evidentiary hearing on the issue of sanctions and attorney fees. After the evidentiary hearing in June 2024, the trial court granted Echard's request for attorney fees and costs. In July, Owens filed a notice of change of judge for cause under Rule 6.1 arguing the judge was biased and had engaged in conduct that violated her right to due process. The presiding judge denied her motion, concluding Owens had failed to prove by a preponderance of the evidence that the judge was biased or prejudiced. Also in July, Owens moved for relief from the judgment, or alternatively to alter or amend the judgment, which the court ultimately denied. In August, the court awarded Echard attorney fees and costs in the amount of $149,000, $219.76. I do that every time I record these. I say dollars too soon. This appeal followed. We have jurisdiction under that.
Arrest Rule 12, basically.
That's right. Exactly. There's a footnote there. The trial courts. Do you want me to read it?
I can't even fucking see it, but sure.
The trial
Oh,
court's
go for it.
August 2024 judgment was not certified as final under the applicable rules. And the June 2024 ruling was improperly certified as appealable under Rule 78B. We therefore suspended the appeal and revested jurisdiction with the trial court to allow it to enter a final appealable order after the court amended, which we remember Judge Mata had to amend that ruling,
Yeah,
right?
it was just super technical, but I think
Right.
it ended up being that there were certain things that the judge that could be appealed before a final judgment, and one of those being attorney's fees, but that in order to actually have an appeal be what we would consider perfected, there had to be no real issues at all left in the case, and judge has to certify that.
So that's what that footnote is. Discussion, attorney fees. Owens argues that because Echard did not comply with Rule 26 safe harbor requirements, she was shielded from any punishment arising from her alleged violation of Rule 26. There's another footnote. Rule 26 provides that by signing a court filing, a party is, among other things, certifying that it is not being filed for any improper purpose. The claims are supported by existing law and are non-frivolous, and the factual contentions have evidentiary support. If a party violates the rule, the trial court may impose sanctions, including reasonable attorney fees. However, goes on forever. Before
Our contentions never had enough evidentiary support.
Right. Preliminary matter. We note that a significant portion of Owens' appellate arguments relies on her incorrect assertion that the trial court ordered sanctions under Rule 26. The court expressly awarded attorney fees and costs under ARS 25-324 and ARS 25-415. We thus decline to consider whether an award under Rule 26 would have been proper. I love that his entire argument was based on Rule 26, and they say
Can you read the beginning of that sentence again, or that paragraph? Yeah. That's hilarious.
Yeah.
Here, the court expressed that one, or however, before seeking sanctions,
as a preliminary matter.
Yeah, as a preliminary matter, we note that a significant portion of Owens' appellate arguments relies on her incorrect assertion that the trial court ordered sanctions under Rule 26. The court expressly awarded them under 25.
Yeah.
We thus declined to consider Rule 25.
Remember when David Jingers said that, hey, Rule 25 doesn't apply because this is not whatever case.
I'm calling ARS 25 Omar's law from now on.
just make it Omar's law as it pertains to gingerbread for all time.
It's official. It's official.
Whenever I want to be an asshole in legal writing, I write like that. It was not. Period. 3-word sentence. You are a fucking idiot.
You're the as per my last email person.
That's when I want to be a dick in legal writing, and I bet it's right in the middle of the page too. Hoax class, dude, just at all times.
Let's see, 7 here. We review the trial court's decision to award attorney fees and sanctions under 324 and 415 for an abuse of discretion. And then they list a couple of cases there for discovery sanctions. But we review a court's interpretation of and application of statutes de novo. Clark versus Clark, Repay versus Repay. Number 8, Owens argues that because the hearing was set in response to Echard's Rule 26 motion, and because he did not file any other motion for fees or sanctions, of course the court sanctioned her under Rule 26, end quote, relying on Rule 35A1. Owens contends a fee or sanctions request must be made by a separate motion.
I'm actually curious about how they handled this one because this was like one of the big conundrums, right?
Yeah, because 35A required the filing of a motion. But I think what I said was the way that the statute is written, it's not an exclusive list of remedies that they're providing. It's a more general list. And in an exclusive list where it says, in order to have sanctions under these specific things, you must do this. That would mean if you don't do it, then you didn't follow the rule. But this was more general, like among some of the sanctions you could file would be for frivolous lawsuit.
My interpretation was like if we're going to have a sanctions hearing, it wasn't going to be exclusively based on 26. It was going to be based on sanctions in general under any authority that would enable it.
Yeah,
that was my thought.
And it says here, well, this is true for Rule 26 sanctions, the Family Law 26C3A. This same is not true for attorney fees requests under 25-324. And
it's supposed to apply indigent bread. Jesus Christ.
And they reference Lundy versus Lundy from 2017. Or sanctions for litigation misconduct under 325.
Sanctions for being a fucking liar and doctoring evidence and HCG tests and all of that. How about that?
And that case says court can impose discovery sanctions under its inherent competent power. And this is family court for y'all.
Yes, it is.
Ruling that affirms for Clayton that this lawsuit was filed for a frivolous purpose. That's a huge win for him.
Yeah.
Mm-hmm. Yes.
Like he can take that to the bank.
You know how hard it is to prove that a complaint was filed for frivolous purposes? It's really fucking hard.
Yeah.
It's really hard.
Yeah, especially in family law too. I would imagine, there are absolutely political considerations these elected judges have to take into account. And like one of them is, how will this affect women? And we saw Laura basically just be able to walk in like it was a Starbucks and get a restraining order.
Yeah. Right. It's such a good way to put it.
Mm-hmm.
I mean, I'll speak to that though. I don't think women have been affected negatively at all. If you're legitimately pregnant, you have mechanisms available to you to prove that to the court. You just give them evidence of your doctor's visits, legitimate pregnancy tests.
Do you have to attend the doctor's visits, or can you just make the
legitimate doctor's visits?
You should probably attend your own doctor's tests that are running blood tests for you, an HCG test.
Are you sure I can't just text a hotline or something?
There should also not be coercive emails where you're threatening to not abort a kid unless you date me. That would be a pretty good indicator,
Yeah, I think that's probably right. Like the court just assessed all of her behavior, like the extortion email the night before her depo. That was
huge.
Wild conduct. Excuse me.
Oh my God. And she went around her lawyer, obviously, because they would have said like, "Oh, don't fucking do that."
It was a settlement offer, Your Honor.
I mean, it's reasonable.
Been a good plaintiff. She would have won.
It's reasonable to judge that if somebody is bringing somebody to family court, they're going to have some sort of clinical proof of pregnancy and paternity.
Mm-hmm.
Okay. If you want to go have a feral pregnancy in the woods, why are you in family court in the first place?
Yeah.
It's unreasonable.
Yeah.
That would have been a good line of questioning for them to have is like, to lay out Laura's level of education, not even like specifically to do with medical stuff, but like, I could definitely see a world where like a person of like low socioeconomical means, no education, no sex education, no nothing, could maybe think these things, maybe not go this far, but she knew better the whole time.
Well, there was signs throughout the entirety of their interactions that she was being coercive and trying to essentially force them into relationships with her, blackmail and all of that. And there was a pattern amongst several men where there was like similar allegations. She had a playbook. And so it wasn't enough to say, look, if it was just this isolated case, that'd be one thing. But there was evidence that it was going on long before Echard ever got involved. This was just the latest in a series of events where she had initiated this strategy against other men. And so
ignorance is no excuse. I mean, if there was literally somebody who didn't understand how people become pregnant or whatever, and they literally get pregnant and take a guy to family court, and he's not a celebrity, and they say, "Oh, I had a miscarriage," and they have some sort of evidence for that, and they get rid of and they just say, "We're going to go our separate ways," and the guy is like, "Okay, fine, whatever." Like, okay, that's fine, but that has no context to this case.
Or if the guy is like, "No, fuck you, bitch. Like, I'm taking you like for fees," and the court's gonna be like,
"There you go.
This woman literally grew up in like like under a rock."
Ignorance of the law is not an excuse to excuse you from the law.
I don't think that's. I think that's probably true in like the criminal context, but
well,
in
this
terms
case
of
is a little bit different.
It was a level of probability. She had to have a reasonable basis to believe she was pregnant.
So
that's why there's a judge to determine if that's true or not in this case for the context.
Based on the context, whether or not her belief was reasonable. And I think there is a context where a woman could believably believe that she was pregnant, and the context suggests that she could believe that, but this is not that case. I'm just saying, like, in those instances, like, that if someone wanted to go after fees against that person, they would probably lose the request for fees. But in this case, like, I don't know who's not telling her this, but like she was guilty. Like, given the context, she was civilly liable for filing a frivolous lawsuit. And what you said, Omar, about like how this is a pattern of behavior, the reason she fought this so hard is because this is the first this is in her head. I don't give a fuck. But in her head, this is the domino effect to the rest of her life. Like, she already overthinks everything. She's probably like, oh my God, she's probably like on the phone with TED Talk right now, like talking about how it's not even like real. I'm appealing.
Well, you could be mistaken about a pregnancy diagnosis and not know what's going on and be like 16 years old and, but inevitably you're going to go to subsequent doctor's visits and receive medical care, and reasonableness kicks in at some point. And so the question was always with her. Did she ever at any point legitimately think that she was pregnant? And it kind of looks like she never thought that.
Would you purchase a baby bump if you thought you were pregnant?
I wish that got proved.
The even funnier thing is, for a woman who has claimed to have been pregnant at least 3 other times and is of decent income, well educated, there the standard of care that's necessary for a pregnancy.
Yeah.
You're well.
That's why the pattern and the context are so important. Because if you go back, that's why she never wanted anybody to go back and look at the Greg Gillespie case, the Mike Maricini case. Because once you see that pattern, like, how could she have done this already and that already and the other thing already, and now we're here? Give me a break.
Right. And not cared for her 26-year-old fake fetus.
Totally.
Oh, wait. Since Jingers made us hear about Rule 26 so many times, can we please just get the reading to the intro paragraph, the preliminary matter paragraph, just one more time? Just in case he didn't hear it.
Preliminary matter. Oh, yeah. Go ahead.
We note that a significant portion of Owens' appellate argument relies on her incorrect assertion that the trial court ordered sanctions under Rule 26. The court expressly awarded attorney's fees and costs under ARS 25-324 and 25-415. We thus decline to consider whether an award under Rule 26 would have been proper.
Not even going to consider it because they weren't seeking it under that specific sanction or sanction statute.
I'm going to pull out my crystal ball and say that right there becomes the basis for appellate attorney's fees. But yes, I'm so excited.
In other words, it's kind of a frivolous motion. He should have known better.
Should have never filed the appeal.
Yep. And that motherfucker knows Laura doesn't have a fucking ultrasound. He knows she's lying. He knows she's mentally unstable, in my opinion, but it's fact. And he's admitted it behind the scenes.
You want to ask my opinion?
And yet he still did all of this shit because he's got a fucking ego and like small dick syndrome.
Definitely that. Low T lawyer. I have been saying for months that he has taken on the role of a predatory attorney that is taking Laura Owens for a ride and probably milking, I don't know for sure, but he's probably, in my opinion, milking her for money on the promise that, oh, there's no way we can lose this appeal. We've heard him say this on his YouTube channel.
I mean, it's not my kink, but whatever.
Well, it was LO's kink because he was the only one that was feeding into this bullshit. Because if it was me or any other reasonable attorney, we would have talked her down from this ledge a long time ago.
Well, you would have been fired then.
And I would have been happily fired.
Like number 13.
Yeah, I would have been happily I would have happily withdrawn.
If I lost that trial, I would be like, I'll give it my best shot at trial. Actually, if I knew the full context, I wouldn't. But if I didn't know the full context, I'll be like, I'll give it my best shot at trial. But then when you lie on the stand or change your story on the stand, like, I'm out. Like, I'm not like, you know what? Pro bono, girl.
I believe in you.
Have you ever had that happen where you had a witness literally change their story on the stand, like in real time during a trial?
I did, but I wasn't there for it. I took the depo.
I've had it happen to me.
On cross, it happened.
I literally had a case where a witness blatantly said that, yeah, I got my story straight with the criminal defendant last night. And so that's why I'm saying everything that I'm saying right now. It's like, you're so guilty, dude. Why did you do that? Oh, that's another story for another day.
Take the plea.
He should have.
Okay, somebody sent a condom holder to my door.
Oh no!
It's a vibrator.
What?
I'm pretty sure it's for the condoms that you sent me last.
It is a miniature.
I was imagining like a toothbrush holder, but for a condom.
That must be what it is.
And what else did you get?
Hang on. That actually makes sense, Patrick. That it's a toothbrush holder because it says this vibrating bolt is for people with vaginas seeking external stimulation. So absolutely, it's definitely a toothbrush holder.
That's right. That is the definition of a toothbrush.
Somebody sent Lauren
I assume so.
A butthole tickler.
Does it use USB or does it need batteries?
I haven't opened
totally
the box
uses USB.
yet, you weirdo.
It uses
I'm here with
Bluetooth.
you.
Open it up. Come on.
I don't know if this is funny or just a high thought, but I can now I can't get the picture of like Laura brushing her teeth with a vibrator. Like,
oh boy,
give me that cum, please.
I can help
Laura
you with that.
Knighty or Laura Owens?
Laura Owens. What was she doing in that bathroom? Like, was she brought a turkey baster? Like, what was? Tell me what you were up to.
We wondered.
Was it like a good old spit and scoop?
Ew.
Was there a straw? Maybe a really long straw.
That sounds messy. I don't even want to think about that.
I think that's what I would do if I had
just a big ass load, and she scoops it off of her face.
Where
and
would you get this straw? You wouldn't have a straw.
No, it'd be like a collapsible straw, like a seeing eye cane.
Oh my God.
Oh Jesus,
Lauren!
Christ.
If that thing uses USB, you got to get to charging it right now. Come on.
Exactly.
Bruce, what do you
Demonstrate
think? This
it.
is not OnlyFans.
What?
This is not OnlyFans.
You can't just brush your teeth on camera.
Well, you know,
here.
for later.
What else did you get?
Bagel bites.
Bagel bites. That sounds great.
I want bagel
They're in the
bites.
freezer. I'm gonna eat them later.
What the hell?
I got crucified for making pizza rolls in the microwave.
How dare you, Brad?
That's a little.
Wait, who crucified you for that?
My Discord friends.
How old are you? 12.
Brad,
I was gonna say that's what I did when I was a kid.
You do not have a toaster oven, Brad?
His pizza bites
no.
and Uncrustables.
We got to get you a toaster oven.
I have a I have a Breville with a toasting oven functionality, but microwave
by
is
the
still
way,
faster.
Uncrustables are the shit, man. I don't know why they're so good. Like, why are they so good?
Everyone is talking about these now. Like they were talking about the NFL eats like 500,000 of these things a year, and I'm
My
like,
ex loved them, and I could care less about Uncrustables.
You can just make your own.
What martial arts did you do? Did you do Krav Maga?
No,
I did,
or are you asking me? Or
traditional.
Brad did martial arts. Really? What'd you do?
I did traditional Okinawan karate.
Totally. I did
Omar,
too. When
look
I was
at
like
Omar. He's like, that's so dreamy.
He is getting all dreamy.
Do I have my?
Oh, I don't know.
Wait,
I'm going
okay,
all
You
full on
served
Joe
in the
Rogan.
military, right?
Yes, I did.
Where were you guys on this document here?
9.
Brad came here to kick ass and chew bubblegum, and he's all out of gum.
Pretty much.
No, he's just
Well,
gonna
maybe
ass.
he should chew my ass. Yeah, that's what I was
Exactly.
gonna do.
What the fuck, Lauren? I feel like
Brad,
that's a foul. That's a foul.
What did
SH.
you think of the leaked the text messages that came off the hard drive? Like when that whole scenario happened, like did that change your perspective on the case, or are you kind of locked in at that point?
I was pretty locked in at that point, but that situation is even funnier because I was the one who recommended the forensics analyst to go through that.
Oh shit!
Yeah. So
And he was ex-military, like intelligence or something.
yeah, he's Air Force, did FBI work, does a lot of federal investigative work on that. So the fact that we got a proper cell braid extraction on that, it just provided that solid piece of proof. And I wish that would have been able to have been discussed in this case.
Mhm.
But I think it will definitely come out in Mike's renewal hearing next year.
Absolutely.
Oh,
This year.
man.
It's this year. June.
Oh, this
June-
year, yeah.
July
Geez.
10th. This year it expires.
Well, if she's bankrupt, I don't know how she's gonna pay another lawyer.
And
Well-
hopefully she'll be in jail.
Let's talk about the practicality of that. Look, I don't think that Echard is going to. I just don't think it's realistic that he's going to collect anything from Laura. I don't know if she has assets, but what he has is a judgment in his hands to place liens on property and to try to chase her for this money for the next 20 years or so. So we'll see.
Would the lien get wiped out if she declared bankruptcy?
No, specifically it would not because it's a legal
Civil lien.
judgment.
It's like a student loan.
Legal judgments are not bankruptable.
Are you sure? Are you? Well,
Yes.
I mean, I know you're a lawyer. I didn't mean that to sound that way, but I didn't mean that way. But just based on conversations I've had,
In California, that's the case. I don't know if it's different in Arizona, but my understanding of it is legal judgments and student loans, you can't bankrupt that shit away. Now, I'm not a bankruptcy lawyer in Arizona,
Mhm.
so if I'm wrong on that, I fully admit defeat.
What if you
I've ju-
like
I've
said
heard-
Rule
I've just heard-
26 to the bank?
I've heard that her way out of this is bankruptcy.
How though? You know what? I'm going to research it right now.
I just assumed she would make up the funds on her podcast, which is thriving, clearly.
Oh,
I'm going to ask
would- I would
LexisNexis.
go Nexus.
but here's the thing. Certain judgments can't be discharged, such as those arising from fraud, willful and malicious injury, or debts obtained through false pretenses. So by filing a false paternity
Frivolous
case
lawsuit. Mhm.
and frivolous lawsuit, that could fall under that non-dischargeable judgment case.
Oh my God, guys, it was just a prank. Like, come on.
What are we talking about?
I just shared my Dropbox one time and wrote a really long Reddit post, and now I'm in bankrupt. Like, yeah, what a turn of events, my dear.
Are legal judgments dischargeable
Oh boy.
in Arizona by virtue of bankruptcy?
Also, I wonder if we're now going to get any kind of public statement from Woodlink the Law now that the appeal has been settled.
No, he should
Well-
just not say anything and let the judgment stand. Let the decision stand.
No, I like mess.
That'd be the pimp thing to do.
Whatever.
That's what I would do.
Fine. Okay, fine. But a girl can dream.
Omar, does it matter this judgment is from family court, not criminal court?
No, I don't think that it's distinct. A legal judgment, whether it's civil or family or criminal, is a legal judgment for bankruptcy purposes. That's my understanding of it.
Okay.
That's what I'm going with.
Maybe criminal restitution though is not dischargeable. So like in a criminal case, if you mug someone and steal their necklace, the court can order you to pay restitution for the necklace. So, and I don't know if you can declare bankruptcy on that restitution order. That would be interesting to know. But now we're in a completely different rabbit hole. Either way, I think we need to start taking over-unders on bankruptcy.
This is what I'm getting from Lexus. Legal judgments in Arizona may or may not be dischargeable in bankruptcy, depending on the nature of the debt and the applicable federal and state laws. Under federal bankruptcy law, certain types of debt are explicitly non-dischargeable, such as those arising from fraud, embezzlement, a fiduciary breach, as outlined in 11 U.S.C. And related provisions. There's case law. In Arizona law provides specific rules regarding judgment liens and their interaction with bankruptcy. A judgment lien does not attach to homestead property if the judgment has been discharged or enforcement enjoined by a bankruptcy court. However, if a judgment lien survives bankruptcy, it may still be enforceable against the debtor's property in rem, as seen in this case.
You can file it against the property.
Yeah.
Clayton owns the casita.
But check this out. Furthermore, debts related to family support obligations such as spousal or child support are generally non-dischargeable. So arguably it is not dischargeable, but it might be.
Yeah, the bankruptcy judge would have to rule on it.
So what did you hear about it, Schnitzel? Why would you think it's dischargeable? Who's saying that?
I cannot. Come on,
But, like,
I can't
what-
tell you.
Well, what indication do you like? What's the argument against it not being dischargeable or being dischargeable?
Just because it wasn't, because it's in family court and what it's for, basically.
I don't know, man. I defer to Arizona attorneys. I just know in California, I'm 99% sure it would not be dischargeable.
If I were counseling a client and they were asking me this question, I would say, like, well, it could fall into one of these categories of non-dischargeable debts, but, she could still file it and a judge could still say that it's not, so either way, if she files it, you're not getting paid right then, and you may not get paid ever. So she's kicking the can down the road with bankruptcy. And that's how I would counsel a client.
I'm looking at AI output, and it's saying that in Arizona case in 2018 for unreasonable actions, the attorney was actually ordered to pay the fees and costs and not the petitioner.
Ooh.
For what, like, misconduct, or was it like some kind of negligence, malpractice?
In the case, a mother and her attorney continued to litigate issues after a binding settlement agreement had already been reached with the father in a paternity matter. The dispute centered on the father's request to protect his address from disclosure, which the mother opposed despite prior agreements, rendering her argument moot. The Arizona Supreme Court found the mother's position objectively unreasonable, noting that her actions caused unnecessary delay and increased litigation costs. The court highlighted personal attacks, inflammatory filings, and the timing of a bankruptcy filing shortly after the father sought fees as evidence of bad faith.
Yeah, but Gingras is not getting ordered to pay Laura's fees. Like, these fees were for conduct that occurred before he came onto the case in March.
Yeah, those facts
after
are
the fees are. Sorry.
I was going to say those facts are almost the exact same as this case, except for the fact that she filed bankruptcy during the litigation. I think that I could see the court enforcing a judgment against the lawyer who helped her with bankruptcy. And if they were one and the same, then yeah, all day I would hold them. And if I was counseling Laura though right now, I'd be like, girl, don't you make 200 G's a year? Like, just get on a payment plan, get this done. And, get your life back. If you do this, you're done for 7 years and you may not even win.
Well, Patrick,
Bro, whose
you have to
face
keep some of
turned into
that
Laura
money,
Owens like that? It's like looking at me and like trying to hypnotize me into like a blowjob or something. Like, fuck, no, man. Stop.
Why does it
Okay.
kind of look like Britney Spears to me?
Nah.
Like, there's a crazy,
that, then
there's a crazy
Jingras's,
Britney look there to me.
Gingras' CPI.
Beautiful.
I am not enticed by that face. I just want it to be clear.
Your dad was.
I know everyone was up in arms about Jingras's post about beautiful girls or whatever. But and I was too. But he also gave like really bad legal advice to someone, like encourage them to just file bankruptcy to get out of a legal judgment.
What
So
I know,
when I saw that, I was like, this dude's gross.
what I know about David Gingras, I mean, well, there's a lot of things I know about him. He's a despicable person. Let's just leave it at that.
Yeah, people sent me some pretty interesting stuff against my will. I know way too much about this person, but I was just like, you know what? If I can't verify it, then I'm just not gonna talk about it. So
Just say allegedly before everything.
yeah, I'm still not gonna do it. I feel like it's still like kind of it would be icky. Like if it wasn't real, there'd be like.
Hey,
way
Lauren, do you
too
want to
icky.
text him to see if he wants to come on your live?
I'm not. I have that man blocked just in case he tries to talk to me. So you know that's not gonna happen. But
Through your counsel.
He then tried to reply to me once in like a YouTube comment.
I'll
section.
text him right now. I was like, "Hey, David, come on Lauren's live, bitch."
No, he knew I had him blocked because he was tweeting about it, and then a little while later he finds me in a YouTube comment section and replies to one of my comments. I was like, "Hey, man, I don't want any contact with you. Please stop." Like,
I remember that.
My guess is that he's at the strip club tonight.
Totally.
well, then I guess I
Double
won't see him.
fisting it
Oh, you
See him
don't
in a
think he's
minute.
playing? You don't think he's playing?
or double fingering it.
Weird ass upstairs man cave.
He would need to show me payment receipts for a significant amount of therapy, and he would need to apologize to Dave Neal's family before I would ever talk to that human being.
Mm-hmm.
That's very actually noble of you, first.
Yeah.
Because I mean, at least you want him to get better, and I think you've even said that about Laura. Like, you know, she's a little too far gone, but you're right. Like, this could have all been solved by just, you know, coming.
I mean,
clean
yeah,
and getting help.
if she legitimately says, "Hey, look, I've struggled with, whatever it is, cluster B personality disorders for my entire life, and now I'm getting help. And here's the
Autism.
proof. Here's the evidence. Whatever it is, I would be open to listening to it."
So the whatever psychiatrist keeps criticizing Justin Baldoni on TikTok, the psychiatrist who sounds actually like kind of a lunatic who like inhaled too much helium, she probably told Laura that she has autism. Yeah.
Hey, I think
it was
I
Grok.
tried so hard, I got so far. In the end, it doesn't even matter.
Guys, that's what Omar sounds like when he climaxes.
To lose it all, but in the end, it doesn't even matter.
When your voice cut down at the end.
Squeak there.
whatever, man.
I don't have a soundboard, but oh yeah.
Omar, will you say "Oh my God" in that voice?
Oh my god. Oh yeah.
I need you to say I need you to say "love you like a sis" or something sissy.
My fake internet lawyer, everyone.
No, not like that. Like you would write in that girl's yearbook.
Endure.
You just sound like a pervert.
Wait, but that wasn't his regular voice.
That was my regular voice, bitch.
That's the voice you have to use for the documentary if you like hide your identity.
Like to
Oh,
hide
yo,
your identity.
Happy birthday, Rob, by the way.
Oh yeah, spank my hairy ass.
And that was his birthday gift to you, I guess.
And this is
Rob?
the guy that outsmarted Gingras about the appeal predictions.
Yo, Omar and I outsmarted that guy on like our coffee breaks. Like
It wasn't
walking
even
my
that hard.
dog.
It took us 5 minutes of
I
legal
know.
research.
That's what I'm
Well, I mean,
saying.
like, also, like, I will say, like, what he was given to work with, like, no sane person would have. This dude would have done it. No sane person would have, like, followed through with this appeal because you have fucking shit to work with, right? So I'll say, like, given what he had to work with, I do think he did the best he could.
Gingras? No, I have to push back on that.
No,
No,
I didn't
his
say the
writing
best
was
someone
not high
could.
quality.
The best he
That
could.
he could. Okay, maybe the best he could.
Even if the only lens you look at his things through is a technical writing perspective. I have 25 years of engineering technical writing in my belt. He is not a good writer.
He isn't.
No.
He isn't. He is God, how would you describe his writing, Bruce? I mean,
think
it's
thick
like
is, I think how Bruce has described it.
Beauty
he's
school
like
dropout.
he's like an 11th grade level writer.
We don't have enough time.
Who writes with a thesaurus, uses words where they don't belong, and makes emotional arguments where they have no place in this legal arena. He writes like a 1L trying to impress his law professor whom he has a crush on.
I don't remember which one it was, but there was one of these appeal documents. I literally went through, I think I had 34, I had 34 critiques of his document. And it was all, like, I'm not a lawyer. It was literally from just somebody who's used to reading technical documents, reading through his short document. And I just had critique after critique after critique. There was just so many problems with it that could have been addressed by a simple editorial sweep by somebody who knows what they're doing in terms of technical writing.
Yeah. There were times, I will say, when he was writing his response to the response, I guess, where he cleaned up his writing a little bit. And I was like, oh, I was pleasantly surprised. This is not actually as bad as I thought it was going to be. But it was still like 1L level writing.
There were still problems in it.
Yeah.
Yeah. I mean, there were places where he dialed in the rhetoric. You're correct. But even let's say he never had any rhetoric. Let's say he never brought up Trump or this weird painting or all the weird things, the really weird things, the lunch.
I forgot all that, dude.
Hey, does anybody have
all that? It's still not good.
Does anyone have Gingris's diary entries from like Reddit? I remember reading those one time.
Oh God.
Did somebody send those to me? Or something like,
you know what? I try to be a nice guy, but I find that nice guys finish last. And so therefore I'm just going to be a dick for all my life. Because of what benefit is it to be nice? I will be an asshole for the rest of eternity.
I remember the post you're talking about exactly because somebody gave me a hard time because I gave him a hard time for generalizing. Because he basically said like, this, generalized thing happens to the good people. And this generalized thing happens to the bad people.
That's what it was. That's what it was.
I'm like,
something
what
like
fucking
that.
scientific test do we do? Where's your Nobel Prize, sir, to give me a scientific test to determine who's a good person and whose a bad person?
He had no
you
test.
Can't.
His test was
it's
his
just
emotions.
Useless, meaningless rhetoric that actually does a disservice to the way you think about other human beings you interact with that is going to have negative consequences.
That's exactly what I was referring to. You said something like that about good people and bad people and whatever and why play by the rules or something like that.
And I get, if I say, hey, Omar, in general, I like chocolate dessert more than other desserts. Like, okay, I'm generalizing and it's harmless, but the way he does it is not harmless.
Yeah. Well, it was like for sinister purposes. He was like specifically saying like, why abide? But he was making like this argument that morality shouldn't apply to his life. And that's how he practiced law. And that's how he took Laura Owens for this ride. It was already bad enough for her, but he just exacerbated it to like this exponential level to where we're now still talking about this shit. It's been over for almost a year. We're still talking about it because of him.
In all of his Twitter tweets and his blog posts and his YouTube videos, he rationalizes with the mental gymnastics. And that's what you're picking up.
Yeah. If you were to ask him about it right now, I promise you, well, number one, he's probably got his phone off anyway. Number two, he's going to come back like in a week and he's going to like completely downplay all of this. And he's going to announce triumphantly that I'm taking this to the Supreme Court and, exclaiming
and
that they're going to
take it to the Supreme Court.
He ain't going to do shit. He's done.
He has 30 days.
Disappear.
He's done.
Good to know. 30 days. The clock is on.
Thumbnail here. It's. I feel like it was kind of a masterpiece.
Oh, that's like my nightmares. Like imagine like you're having like a sex dream and like the person writing you is that one in the middle.
Absolutely. I'm gonna look at this later and brush my teeth.
Getting pegged by Gingras Laura Owens.
I'd rather dream about love loves.
Can you send me? Are you able to send me like the middle picture from that? I want to make that my Reddit profile.
Yeah. Give me a sec.
I tried to like do that thing where you can make a sticker out of it, but it did not work.
Oh no. should we continue reading this thing since we have 7 pages left? I guess.
Yes. Number 9.
Ooh, continue.
I don't know where you
Woo!
guys left off.
Number 9.
Voices are outlawed.
You're right.
Preliminarily.
Oh, I irritate Bruce so much with my voices. I'll pick up the reading if y'all want me to. I'll start from
go ahead.
paragraph 9.
Go ahead. Yeah.
Voices are outlawed. All right, Bruce. Nevertheless, Echard properly requested attorney fees and costs under those authorities throughout the litigation. For example, he requested attorney fees and costs under 25.324 based on Owens' unreasonableness. In his motion to extend the dismissal date on the inactive calendar and schedule an evidentiary hearing, which was filed before Owens moved to dismiss the case, Echard made the same request under 25.324 in his reply, as well as in an amended response to the paternity petition. Moreover, in Echard's motion to withdraw his Rule 26 motion, he argued that he was entitled to attorney fees and costs under ARS 25.324, 415, and 809G, and that his claims for fees and sanctions exist independently of Rule 26. These requests were also repeated with supporting arguments in his pretrial statement. Owens argues the trial court lacked the authority to impose attorney fees and sanctions independently from Rule 26 because Echard filed and subsequently withdrew the Rule 26 motion. He maintains that Rule 26 must control and must provide the exclusive remedy for conduct. Page.
Once invoked. Oh my god.
Oh, I totally
Oh, one thing that I don't think people like without a nerdy legal background, maybe they do understand, but when Clayton was able to amend his original answer or reply to the lawsuit, that amendment, becomes effective as if it was like originally filed way back in August. So that's what never made sense to me. It was like, even if the court doesn't accept what Clayton hand wrote in, they allowed him to amend his original complaint to specifically include it. So I don't know how Janus was just like thought this was
because he's not the R word. He's, what was the word we were going to say? Preposterous. Whenever I say preposterous, just imagine that I'm saying the R word as if it's 1987, where you're not canceled for saying such. Anyway, she maintains that Rule 26 must control and must provide the exclusive remedy for conduct that would fall under a Rule 26 violation. The court's about to dunk on him. I could feel it. In support of this argument, she relies on the proposition that when two rules deal with the same subject, the more specific rule controls. I've literally never heard that legal reasoning anywhere other than within a Gingras appeal. In Re Marriage of Thorn 235 Arizona 216, but the statutes under the court, which the court granted attorney fees, do not govern the same subject matter as Rule 26. Isn't that what we said, Patrick? Didn't we say this like way back when? Well, Section 25.324 governs attorney fees, not sanctions. And the sanctions for costs and attorney fees that the court ordered under 25.415 were based on Owens knowingly presenting a false claim and knowingly violating a court order, compelling disclosure or discovery, which is distinct from conduct that would constitute a Rule 26 violation. Compare 25.415A3 with Arizona Rule of Family Law 26C. We decline to hastily find a clash between a statute and court rule, especially when the statute and rule govern different subjects. Logical.
So, Omar, here's the thing. If you're looking at two rules like this, is it like an inclusive or?
No, it's like specifically, like Rule 26 deals specifically with sanctions. Rule 25 is not even in the same category. It's basically stating that if you are found to have knowingly lied in court, then you will be responsible for attorney fees and costs. It's not the same as a sanction. Sanctions are discretionary. Attorney fees are whatever the attorney fees were, and it's at the discretion of the court to award up to the actual attorney fees or some lower amount
I
based
get it.
on
I get
whatever.
it. I'm asking sort of an orthogonal question. If you are in a situation where you're looking at two rules,
Yeah.
and she's making this argument, where was it?
By analogy, basically.
The more specific rule, or something, or was that?
Oh yeah, the one with the more stringent rules should control.
And you said no. My question is, what is it then? Is it an inclusive or function, or what is it?
I guess the way that I would answer that is if there is a rule that is less restrictive, it's there for a reason. And so we're not going to, through loopholes or legal innuendo, disregard arguments that would ordinarily lead to sanctions or award of attorney fees for the sake of this more stringent rule that applies in more stringent scenarios.
So you look at the context and you say one of these rules could apply, or the other, or both. Is that correct?
Yeah.
Okay.
And so, for example,
that's inclusive or. That's the inclusive or function.
Inclusive or. Yeah.
Well, there's also like a whole body of law called conflicts of law, where exactly what you're describing is studied. Like there's two different laws, both could apply. Which one takes priority over the other one? And this one, it's either or, I think. But I also, when I read it, like to me, I don't know much about conflicts of law, but to me, a conflict of law has to be identical requirements, and these weren't identical. That's why I don't think I think it's more towards what what Omar was saying, that it depends. It's like one of them could function and one of them could function, but this is the one that meets all the criteria.
There has to be judgment about applicability.
Let me, I got to interrupt this with a public service announcement based on something we saw in the chat here. Yes, Sarah Boone is in fact back on her bullshit. She is now filed for control of child support. So,
what?
Yes, we will get to that probably Sunday or something like that.
She has kids.
So you can see she wants control of the child support. Yes, she has kids. She wants control of the child support money. A couple of streamers have filed this, but I haven't been able to obtain the filings myself. But she's filed a motion demanding alimony, child support, and money for something else here. But I saw this a couple days ago. This girl, Tanika's 2 cents, if you want to hear that, she's got some good stuff on her channel. She follows that pretty closely. I just haven't gotten to it yet because I want to get the actual documents before I do. So, all right.
Cases
Anyways,
are ongoing.
So to follow up on what Bruce was saying, it's a lot more simple. Like Rule 26 implicates a specific thing.
Yeah.
Rule 25 implicates a different thing.
Mm-hmm.
You can't just say because of Rule 26 it invalidates these other issues that were not covered under Rule 26.
Just because you mention it once, like Voldemort, doesn't mean.
Yeah.
Yeah.
Exactly. It's exactly.
Yep.
Where were we at with this one? I've completely lost my place.
We're at the end of 10, so we're on 11.
It was after the court read like 5 different examples of Clayton asking for anything but.
Right.
11.
So Owens next argues that the attorney fees and costs awarded under 25.324 and 415 were improper because they were neither necessary nor reasonable, which was like his weakest argument, right? She asserts Echard's fees were literally zero prior to November of 2023. And it's not about her fees, though. It's about the fees that Echard incurred.
I love the shade that using his exact language, literally.
Yeah.
That
we
is some shade,
give
though.
us a literally.
It's the fees in total, right? It doesn't matter.
If he incurred costs, it's the entire thing. It doesn't matter if she didn't have an attorney. If he had to hire an attorney to defend himself against her, that's what we're talking about. There was a time where he was pro per. I think it was like September, October of 23 that he hired attorneys. I think.
Well, her argument was when I said, "Hey, I'm no longer pregnant," he didn't have an attorney. That was the argument, right?
Yes. So she asserts fees were literally zero.
You know, the problem is at that point when she said, "I'm no longer pregnant," or even up to the point where he never had an attorney. I mean, there were replies, right? Like he had responded.
No, yeah, he responded like in
the
August,
case, right?
He was right. No, he responded. he was fighting the litigation, and it was his contention since August, since from the very beginning in his very first filing. He said that I don't think that she's pregnant, basically. He said, I think that she's lying. He said, I think this is a frivolous petition. He said that back in August. And so it would have been one thing to say that after the fact, after she miscarried, but he said that from the very beginning.
First thing out of that
my
dude's
understanding
mouth.
is once he replies, it's like the horses are out of the gate and you're
Yeah.
off.
It's not
Off
up to
you go.
her to dismiss.
Off you go.
Exactly. Right. Exactly right.
A responsive pleading, shuts down the ability to dismiss.
Yeah. So continuing, prior to November 2020, and if his counsel had simply picked up the phone in mid-December and asked her about her intentions, she would have informed him that she was no longer pregnant and there was nothing further to litigate. She similarly argues that Echard's decision to file the Rule 26 motion was the precipitating factor in incurring fees. She contends that if Echard had done nothing, the case would have been administratively dismissed without a single dollar or fees incurred by either side. Therefore, she maintains that even if her petition were unreasonable, it was not the filing itself that caused fees to be incurred, but rather Echard's choice to pursue sanctions. But that administrative dismissal would have been without prejudice, so it would not have precluded Owens from initiating a future paternity action, nor would that dismissal have been equivalent to the order Echard sought and ultimately obtained, that he was not the father in connection with the alleged pregnancy. At any rate, none of these scenarios posited by Owens.
The thing, right? That's a hypothetical argument.
Yeah.
If we had done this, this is how it would have played out.
Right.
But that's not what happened. That's not
So what they're saying
anybody
is
wanted.
Echard was asking for specific findings that would not have been satisfied by an administrative dismissal.
Yeah.
Dismissal with prejudice. She could have brought it again in a few months or whatever. And so
Jingers's backup argument was she filed the motion to dismiss and it was improperly denied, right? Oh, because it should have been administratively dismissed. Wow, the court, I mean, I'm not surprised these people are smart, but that's such an obvious thing. Like, yeah, of course it would be dismissed without prejudice, which means that it wouldn't have been a done deal.
Yeah.
Right. But also, it would not have been administratively dismissed if Echard wanted to pursue sanctions.
Right.
It would have been up to him. They would have asked him the question, do you want to dismiss? And he would have said, no, I want sanctions. Okay.
Yeah,
I
we talked
literally
about
just
it,
had
like,
the same example like a couple weeks ago in another civil case.
we talked about how like the ball was in his court. I remember saying that.
Yeah, this is a non sequitur argument on her part because it's a scenario that never existed in the first place.
Right. So they continue. At the time of Echard's request for an evidentiary hearing on the paternity issue, attorney fees, and Rule 26 sanctions, Owens had not informed him that she was going to move to dismiss the case, and in her response to Echard's request, filed simultaneously with her motion to dismiss, she acknowledged that the only remaining issue was Echard's request for attorney fees. Echard objected to Owens' motion to dismiss, arguing her avowal that she was no longer pregnant was insufficient to grant a dismissal. He also requested an adjudication that she was never pregnant, or at least that she was never pregnant by him, and an evidentiary hearing on his attorney fees request. The trial court ultimately granted Echard's motion to extend the dismissal deadline, stating the issue of sanctions and attorney fees remain. Owens does not challenge this ruling on appeal, and the fact that the parties incurred attorney fees because they heavily litigated these issues was within the court's discretion to consider, and not something this court will reweigh. In other words, David, shut the fuck up with all of this.
We told you. Julie told you. And everyone on Reddit told you. Now we're
And
telling
her
you.
dad told you, kind of.
Oh boy.
Do you remember that? Do you remember that thing where he was like,
Bitch is running wild, man.
yeah, I couldn't believe it. Where it's like, I couldn't believe it.
I couldn't believe it. I had to listen to it twice. I heard in the background, and they were saying that Mata's dad was there, and I was like, dude, what the fuck? This is such an egregious miscarriage of justice. I cannot stand for it. And then I called the FBI, and then I got my ass kicked by David Wignick because I'm a substandard attorney.
David Woodnick.
Don't stand up.
Totally. All right. So here the trial court found Owens had acted unreasonably in the litigation. This was the heart of it. By filing the case without basis or merit. It was a finding, not an allegation. They found that. An applicant need not show both a financial disparity and an unreasonable opponent in order to qualify for consideration for an award. The court also found it disingenuous at best, but certainly misleading to the court, that Owens had testified the purpose of her motion seeking mediation was to inform Echard the pregnancy was not viable, which is such a stupid argument.
Damn.
It further found she had failed to comply with disclosure requirements, which caused Echard to incur substantial legal fees, attempting to locate records that may or may not have existed. The court also concluded that 25-324 applied because Owens had provided false testimony as to the viability of pregnancy and had sent Echard a letter prior to her deposition that indicated her intention to sue him for $1.4 million in collateral allegations unless he agreed to dismiss this action that she initiated, which in the eyes of the law is an illegal attempt at extortion, which I think is going to bring criminal charges in this case, potentially.
It's interesting they mentioned that here.
Yes, it's really important because it was mentioned in the judgment. They're reaffirming it here in the appeal.
Yeah.
But it was
They
something.
find her most egregious, like quasi criminal conduct in, like, they're talking about it in the mediation thing, and now that.
Yeah. It continues. It further found she had failed to comply with disclosure requirements, which caused Echard to incur substantial legal fees to locate. Did I read this part already? I think I did.
Nope.
Oh, I didn't?
Nope.
The court also concluded that 25-324B applied because Owens had provided false testimonies to the viability of her pregnancy and had sent Echard a letter prior to. I did read this part. On appeal, Owens does not meaningfully challenge these findings, but instead argues that 25-324 does not apply in paternity actions. Section 325 or 25-324A permits a court to order a party to pay a reasonable amount to the other party for the cost and expenses of maintaining or defending any proceeding under Chapter 3 or Chapter 4, Article 1 of this title. Chapter 3 governs dissolution of marriage, and relevant here, Chapter 4, Article 1 governs legal decision making and parenting time, dipshit. It was a parenting petition
time that you pointed out originally.
Owens argues that paternity actions are by definition excluded. He's such a fucking dumbass. Oh, I'm so upset at how dumb he is with this argument.
But you gotta feel good. Like
it's like
nice
he
having
never.
a judge tell you you're right.
It's
I
like
feel
he
good,
never
but-
read her filing, like the original filing she put into family court, saying what she wanted and all the holidays. It's like he never even bothered to read it.
Maybe he was like a pelican and just stuck his head in the sand. He's like, you know what? I didn't read any of that. As before my time. Doesn't apply to me.
From
Yeah, it does,
his
bitch.
own mouth, he said it is his job to do as little work as possible. And I think the amount
Well, he did.
of, I think the quality of his appellate brief shows that.
No, it's just
did
such an absurd, ludicrous argument to
But
make.
he did so much work on Twitter.
That's where he spent most of his time. A family court's authority to conduct legal decision-making and parenting time proceedings is provided by ARS 25402, and under that statute, a parent is required to request such a determination in any proceeding for marital dissolution, legal separation, annulment, paternity, or modification of an earlier decree or judgment. Here, Owens petitioned the trial court for orders concerning paternity, legal decision-making, parenting time, and child support. While the court
Literally.
ultimately did not issue the legal decision-making and parenting time orders, Echard defended any proceeding under Chapter 4, Article 1 of this title by virtue of Owens' petition, as was reflected in his amended response. Even assuming the trial court's fee award was improper under 25-324. Because of this case's procedural posture, the court's finding would have supported a fee award under 25-809G. In other words, if we
What is
fucked up
that
under
one?
that, we got this other one.
Yeah, I wonder what that one is.
Rule 25
809.
has us completely covered here.
Echard
Yeah.
cited 25-809 in seeking attorney fees, so the issue was properly before the court. The language in 809G largely mirrors that in 324A and permits a court to order a party to pay a reasonable amount to the other party for the costs and expenses of maintaining or defending any paternity proceeding. We reject
Oh yeah, that was the big broad one. It was basically like
the
this is
catch-all.
family court, bro. Like
Yeah.
if you come in here with your bullshit, you are on the hook. And I think you said that, Omar. You're like, anytime you step into the arena in family court, you
Yeah.
know if you pull some bullshit, you are up on attorney fees.
Do you remember what Jinger said to me? Well, at first he's like, you know what?
I know what he
I'm
said.
not a family
I
law
love
attorney.
you, Omar. Yeah.
I said, Omar, I will- man. He said first, you know what? I'm not a family law attorney. I practice mostly in civil. And when I pointed that out, like, yeah, he doesn't understand how it works in families. Like, I have been a practicing attorney for 20 years, and Omar's not even licensed in Arizona. But I know the
And
law
when I
better than you
started
do,
as
bitch.
an attorney, I did a couple of paternity case or a couple of family law cases. And like, dude, just sit down.
He was out of his depth this entire time. So
And none of Omar's cases came up in his search, so obviously Omar doesn't know how to be a lawyer.
I don't know. I guess I just know how to do PR better than him. Keep my clients out of the public spotlight. Maybe
Yeah.
that's the thing.
He said something like, yeah, you'd never done any high profile cases or something. And I'm like, is it good to do high profile
Most
cases?
family
Like,
court
Sadly,
cases.
is not.
isn't it good to
Well,
just
I'll tell you who has
do your
done a ton
case
of them and never
finish them
talks
and-
about it.
Isn't it good to
Woodnick.
just do your case and make your money
Oh.
and get the fuck out, like Woodnick or whoever? Yeah.
Yeah.
Exactly.
Yeah,
Would they-
generally attorneys don't go like extolling their high profile cases to the public because it's counterintuitive and not in the best interest of their clients. Like Schnitzel just said, Winnick has done a bunch and doesn't go like bragging about it. Gingerbread was on Dr. Phil one time, and it's like his crowning achievement.
They didn't even fucking talk.
Didn't even say she just sat there and looked like a penis with a little hat on.
Well,
He didn't have that.
okay, I know it's been a while, but I've never seen a penis that looked like that. So
I know it's been a while.
That's what they look like. When you turn the light on like a cockroach, he was like real scared all of a sudden.
He looked like an uncircumcised penis,
again,
He's so greasy.
unwashed.
I hope your mother's not still listening to this, Patrick.
Oh, my mom knows better. I've toned
Yeah,
myself down a
should.
lot because of my mom.
No, your mom. I ruined your mom already. I'm talking about Patrick's mom.
Oh,
Hey, she's not ready for it, but it's 11 o'clock. If she is, she's asleep. So she's just adding to the view count, baby.
I mean, I could test that out for a second if you want.
so this is
Hey,
the dunk.
by the way, there's a wild cut.
This is the dunk on Jingers right here. We reject Owens' suggestion that this paternity action somehow transformed into some other type of proceeding because the parties only incurred fees after it was scheduled for administrative dismissal without prejudice. The court did not err in awarding attorney fees. Bitch. The trial
Nice.
court also properly awarded fees and costs as a sanction under 25-415. The court found that fees under this statute were appropriate because Owens had knowingly violated a court order, compelling disclosure or discovery. Owens argues she fully complied with the court's disclosure order, as was demonstrated by the fact Echard never brought any motions seeking sanctions under 25-415. She argues because that's a... What do you think about that argument, Patrick? That's just so... Oh, I can't.
I mean, that argument led me to think, okay, well, is the court allowed to provide those sanctions to Esponte? And then I was like, well, of fucking course they are.
Yeah,
so
it is.
even if that's true, who gives a shit?
It's just not... I don't know, man. 25-415 does not require the filing of a separate motion. You could raise it orally, as Owens has multiple times. As previously noted, Echard requested relief under the statute. Section 25-415A3 states that the court shall sanction, shall, and you and I, Patrick, and I think all of you had circled and highlighted and underlined this word, shall sanction a litigant for costs and reasonable attorney fees incurred by an adverse party if the court finds that the litigant violated a court order, compelling disclosure or discovery, and here the court made such a finding Thus, it was required to sanction Owens for the cost and reasonable attorney fees that Echard had occurred. Owens does not meaningfully challenge that finding. Again, the court did not err in awarding Echard his costs and reasonable attorney fees because they shall issue those attorney fees and costs.
Can you read that footnote 5?
Totally. Section 25415A3 provides 2 exceptions. If the court finds that the failure to obey the order was substantially justified or that other circumstances make an award of expenses unjust, it is not required to impose sanctions, but they got to make that finding, and that's a narrow exception.
It's up to the
And
judge.
she didn't
Right.
argue that, which actually she should have. So that left that money on the table.
Oh, 100%.
Right.
That should have been the key thing in their appeal.
That would have been something that Jingras should have raised when he was unfamiliar with the facts of the case back in like April. But he didn't. So here we are. On appeal, Owens also claims that the amount of the fee award was unreasonable. The substance of her argument is that below she had noted the amount of fees was patently unreasonable in light of the controlling standard of Ethical Rule 1.5. But because she fails to identify with any particularity what evidence supports her argument, we conclude that the court did not abuse its discretion in fixing the amount of attorney fees it awarded Echard. Denial of motion for relief of judgment.
So good.
Isn't that just like a dunk? It's like your argument was stupid. You didn't even argue the correct points, and we reject your existence in this case.
I
And
don't
they
even.
rejected his
Your
evidence,
whole
which was like
existence.
that. Like he
Jeez.
tried to provide some like printout of like normal attorney fees, and I think he humble bragged about like I sit on the fee arbitration, like not for
Yeah.
long, bitch.
Oh, this wasn't a normal case, and it was heavily litigated, and it was reasonably high profile as to subject the parties to abnormal levels of scrutiny and public ridicule, not just for Owens, but Echard had to go through this very publicly. And the other people that were in this case, this was a very trying case for everybody that was involved. Owens argues that the trial court erred by denying her motion for relief from judgment, or alternatively, to alter or amend the judgment. We review the denial of such motions for an abuse of discretion. Because Owens does not argue how the court erred in denying her motion, but instead asserts that the only available remedy is automatic reversal, because the misconduct is per se structural error of the most obvious kind. That's a dunk. We do not address the court's denial of her motion because you argued the wrong fucking thing.
Yep, this is where he should have brought up the court should have amended the judgment because of the Planned Parenthood thing, and that was material to it. And then he would have at least created a basis for this argument. Right now, he has nothing.
So this is a full-hearted, a full-throated rejection of Gingerbread's argument, and kind of a dunk and a slam in that you didn't even argue the right fucking arguments. So we reject your argument because it's per se stupid and structurally deficient because it's dumb.
The court is literally telling you this is what you should have done.
Yes. And that's got to make you feel shitty no matter what kind of lawyer you are.
Yeah, if you're a lawyer reading that,
I would be pissed.
Like, pissed.
Yeah. I would be more pissed because there was all these other attorneys telling you that you were a dumbass, and you said, oh, no, they don't know this and that because I've been practicing. I was on Dr. Phil, whatever. Fuck off, dude. You were completely wrong the entire time.
I think he's the clout chaser at the end of the day, and he just was really milking Laura more for the connections than for the actual legal work, because he's not actually a talented lawyer. He's a talented schmoozer.
He's a talented bullshitter is what he is.
Yes.
I think you said it better than I. A talented schmoozer. He will toss your salad for clout. I think sums up David Jingras' career.
He's got the tongs.
The fuck does that mean?
Like for tossing a salad? I don't know, man. It's late. It's fucking late. He's got the dressing. The dressing, would that have been funnier?
Caesar dressing, a little bit of blue cheese.
Wow.
Ah!
What the fuck? We're doing this all on Lauren's stream.
I'm horrified.
All right, let's go into a judicial bias. We got like 2 pages to go.
There's no dressing in there, is there?
No.
Just at the end for the big finish.
That's right.
My God. Could I do the voice, Bruce? No, I don't want to do the
The
voice.
court just finished on Gingrich once, and now it's about to have its seconds.
You can do you can do a little voice or two when we finish the document.
All right. Hey, does Patrick, do you want to take over or should I finish?
I'm literally driving the U-Haul. I wasn't lying about that.
Yeah, go
All
ahead,
right.
Patrick. Go ahead.
He said he's driving. That's not a commit vehicle.
That wasn't actually a request. You better start reading right now. Or I'm going to wake up your mother and I'm going to start saying bad words again.
Preliminarily, that's the only word I know from this judgment.
Owens argues the trial court improperly performed an independent and undisclosed investigation into the facts of this case, and from this investigation made post-trial findings not based on the evidence admitted at trial. In the findings of fact section of its ruling, the court stated that Echard's expert had testified that Planned Parenthood is not open on Sundays when Owens testified she sought care July 2nd, 2023. The parties agree the expert did not testify that Planned Parenthood is closed on Sundays and that the court's finding was therefore erroneous. Instead, they dispute which standard of review should apply. Owens argues this amounted to structural error, requiring automatic reversal because it proves the trial judge was biased, as shown by the judge's decision to engage in unlawful conduct which violated her right to due process. Conversely, Echard argues that the controlling standard for alleged mistakes in family law proceedings is harmless error. Structural error is generally applied in criminal cases. They're basically telling Gingras that he doesn't know what structural error means. Structural error in general applied in criminal cases and is error that affects the framework within the trial proceeds rather than simply an error in the trial process itself. The Supreme Court has defined relatively few instances in which we should regard error as structural. But one of those instances is a biased trial judge. We nevertheless decline to provide or apply a structural error analysis given the record before us. Here, Owens moved for a change of judge for cause under Rule 6.1 on the basis of bias and prejudice within the meaning of ARS 12409B5. The presiding judge denied the motion while acknowledging that the trial court's finding about Planned Parenthood's business hours was clearly erroneous. The presiding judge concluded that Owens had failed to show by a preponderance of the evidence that this finding reflected bias or prejudice against her. Owens contends that we need not separately decide whether the presiding judge erred when she denied Owens notice of change of judge for cause, because she requested relief is subsumed within the structural error arguments that we must review de novo. But as we explained below, the record does not show that the trial judge was biased. Thus, even assuming without deciding the structural error applies in family cases, it did not occur, and the presiding judge did not abuse her discretion in denying Owens' motion for change of judge for cause. I feel like, Patrick, you and I, we could just like replay our arguments from like 3 months ago, and it would fit right here. Owens argues.
Why do I feel like that's your sex playlist?
That's what she said.
So wait, let me see if I understand. If you wanted to make the case that this was structural argument, you have to prove the judge's bias.
Yes.
Right.
Because there's no other structural error argument pathway either that exists or that they took.
They specifically said, look, there's only a few legitimate cases of structural error. You basically got to prove the judge is biased.
Yeah.
And there's specifically a finding that she was not.
I don't know what the others would be.
Yeah.
Maybe there's more.
There's more, but it doesn't matter because their claim was biased judge.
They didn't argue any of the other avenues for structural
So they don't
error.
even have to consider them.
Well, yeah, because that's like you were put on murder without like the right to an attorney.
No, I get it. Yeah.
Okay.
Right.
But what I think is
some
interesting that the
constitutional
court says-
violation.
Yeah, like other structural bases. But what's interesting, the court said, Omar, that we didn't even think about. I think because we just were like, this is stupid. Like Gingras tried to say, and ignore the presiding judge, so Mata's boss's ruling, because you should decide that this is structural error on your own. And the court is literally telling him, like, bro, you didn't even talk about this.
Right.
And even if you didn't talk about it, we're going to find that the presiding judge did her job. So, like, here come the attorney fees.
Exactly. In other words, you don't even know what structural error means, bitch. You argued the wrong stuff. I could only consider the bias thing. And there was specifically a finding that she wasn't biased. And then I feel like they're going to probably talk about harmless error right now. Owens argues the trial court's erroneous finding of fact demonstrated it was biased and therefore committed structural error. Argument is based on conjecture. She does not provide any evidence showing actual bias. Not even the dad thing? I feel like this is where they should have applied, right? That Mata's dad was at the trial watching in pride as her daughter tried this high-profile case in Arizona. That would have been what Gingerbread would say.
Well, that's evidence that he attended the trial. It's not evidence.
Exactly. And that's
It's
what the court is
he
acknowledging.
even attended the trial. He certainly
claim
didn't
of
prove
bias
it.
is
He didn't have the guy's driver's license or anything.
So it's based on her assertion that the court intentionally tried to conceal its misconduct in performing its own post-trial investigation into the facts by falsely attributing to testimony to Echard's expert. Owens claimed this is the only plausible conclusion, given the outline supporters of Echard had vociferously posted about this issue online hours after the trial ended. These unsupported and speculative allegations failed to meet her burden to prove bias by a preponderance of the evidence, which is like the lowest standard.
And this gets exactly back to show, don't tell.
Right.
They're always like trying to tell you something, and they don't show you the evidence that will convince you.
Owens further contends that any independent factual investigation by a trial judge is unlawful and shows bias. But for structural error review to apply, the type of judicial bias that must be shown is that which implicates a party's due process rights, such as bias based on a direct, personal, substantial, pecuniary interest. None of those grounds apply. God damn it, Lauren. We'll just skip that part. None of those grounds apply here. We therefore review for an abuse of discretion. While a trial court's reliance on extrajudicial information may give rise to a claim of judicial bias, apart from any structural error claim, the critical inquiry that would require reversal is whether the conduct demonstrates an extrajudicial source of bias or deep-seated favoritism. Owens correctly notes that the court misstated trial testimony, but she is incorrect in asserting that because harmless error analysis does not apply, she does not need to make a separate showing of resulting prejudice. Prejudice will not be presumed, but must be evidenced from the record. Therefore,
Presumed.
Even if the court conducted independent research under a prejudice analysis, we would still have to determine whether Planned Parenthood's business hours were vitally important to the court's ultimate conclusions, as Owens claims. What did we say, Patrick? The Planned Parenthood hours were so tangential to the ruling as to be insignificant and not matter. That's what we said months ago.
Certainly were not, because no medical provider ever sent an ultrasound directly from the provider to Greg Woodnick. Therefore, anything about any ultrasound is completely irrelevant. Other than her admission that she, faked information or took a medical record and adjusted
changed headers and whatnot.
Yeah. But in terms of like the non-paternity ruling, it's irrelevant because it's the absence of all those ultrasounds that is what matters. Not like whether Planned Parenthood was open or not.
It was all the other stuff that they said. Like nobody was giving a shit. It didn't matter about the hours because of all the other stuff. Exactly what you said, Bruce. Owens does not argue prejudice.
Oh, I was just gonna say real quick, like hearing the appeals court lay it out at like such a high level view, like and not so in the weeds as we've been, it really makes me realize how much more frivolous his appeal was than I had ever even imagined. Like, of course, you have to make a harmless error analysis.
That we weren't crazy in what we were discussing earlier.
Because you and I were both like, why is he saying this? Because even if, exactly what you said, even if this is true, it's harmless error because of the mediation, because of the extortion letter, because of XYZ. We were like, it's harmless.
For sure. For sure. So to conclude, Owens does not argue prejudice. Consequently, the presiding judge did not err in denying Owens' motion for change of judge for cause. In other words, once again, Gingerbread argued the wrong thing.
They completely threw out the argument. They said, we're not even considering this an actual argument for prejudice.
Right. The record does not show judicial bias, and Owens does not challenge any of the presiding judge's rulings under the appropriate standards for appellate review. Owens and Echard, attorney fees on appeal. Owens and Echard request their attorney fees and costs on appeal under 25809. Echard additionally requests fees and costs under 25324. Under both statutes, the court may award attorney fees and costs after considering the financial resources of both parties and the reasonableness of the positions each party has taken throughout the proceedings. While the record does not support a disparity in the parties' financial resources, Owens' position on appeal is unreasonable. Her Rule 26 argument is not grounded in law or facts. Likewise, her assertion that trial judge was biased and committed structural error does not meaningfully address the trial court's rulings below and also ignores the applicable jurisprudence. We therefore award Echard his reasonable attorney fees and costs on appeal upon his compliance with Rule 21. For the foregoing reasons, we affirm the trial court's judgments. That is the most resounding loss you could possibly take, is saying that your arguments, not only do they have no merits, they're not even the right fucking arguments. You're not even arguing the right issues.
They're not the appropriate standards for appellate review.
Patrick?
How could you read this?
Patrick, somebody wants to know what kind of law you work in. They're asking.
I do in-house counsel work, so I do like a little bit of everything. But I mostly focus on like contracts and intellectual property.
Gotcha.
Nice.
That is so fucking good.
So Patrick and Omar, in reading this, how could you imagine saying, "Yeah, we'll appeal to the next level"? Like I can't even imagine it.
Jesus Christ. I think I would if I got a decision like that, I would be embarrassed. I would be embarrassed to talk to my client because I had so deceived my client into thinking that I knew what I was talking about. And quite obviously, the court resoundingly said I was full of shit the entire time.
Yeah.
Didn't even argue the correct issues, didn't know the issues that should be argued. There was no merit to my argument such that they even considered the merits of any of his arguments. They just said, they don't even apply, dipshit. What are we doing? That's the reason why they didn't allow the oral arguments, because his arguments had zero merit. They didn't even consider them on their merit.
That's right.
This seems like such a GTFO that I don't even know where anybody would even possibly go from here with another appeal.
So
if
Bruce,
Owens,
I don't think that he'll do it, because at this point, if he continues to appeal on her behalf, he's setting himself up for another referral from the Supreme Court.
Yeah.
So if I were him, and I'm not an idiot, I would tell her, if you want to do this, like, I can't be your lawyer. It's too much of a professional risk to me. I don't even have malpractice insurance.
Yeah.
Oh, that's right. I keep forgetting about that.
He might not have a license by the time this thing would be ripe for the next stage of appeal.
Right.
And to the extent that if Laura Owens hires David Gingras to continue with this appeal, she really is a dumbass. I don't know what else to say. Like if this isn't eye-opening enough that this guy doesn't know what the fuck he's doing, I don't know what to tell her. I don't know what to tell her, man.
Okay, so Omar, my final question then for you guys is, having read through this appeal result and the original, court case result, how useful is the result of this case and the appeal to these men who have standing orders of protection against them filed by Laura Owens?
Well, it means that, like it meant before, that there's been a finding after a trial that she has been deceitful in her recitation of the facts. That not only was there a finding, but it was taken up on appeal and affirmed. And so therefore, it doesn't really affect the prior findings from the other two cases. What was it? Maricini and
Gillespie.
yeah, those factual findings stand on their own merit, but it is evidence that she's once been found to be deceitful to the court. It damages her credibility if correctly presented to a trial judge in an evidentiary hearing, arguing that perhaps she has this pattern of lying to the court, and it's been found to be true that she's a liar in Arizona trial court and affirmed in the appellate court. It may serve to bolster their argument that she's less than truthful. But other than that, it doesn't really do a whole lot more because they're dealing with completely different sets of facts.
Does timing matter? Because Mike
Well, I know
specifically being 10 years ago, you have Greg being prior to most of the actions here, except for Greg's renewal, which happened 3 months ago.
Greg's renewal was unchallenged. It was not opposed. And so they just granted it.
But
I don't
they
know
have
what would have happened
He
if
has
they
2
opposed it.
years to. He can request a counter hearing at any point.
I was
in
going to
those
say,
years.
because at the same time, Maricini had his order of protection granted against him without an actual evidentiary hearing. So there's still room to raise that issue. Say, look, I know that you granted this, but we never had a hearing on it. I just agreed to it because I didn't want to talk to her anymore. But now I want to clear my name and I want an actual evidentiary hearing. Now that we have more facts that she's done this to other men, it's a pattern of behavior on her part, and I want it litigated. She can do that, or he can do that.
Yeah, I think the ruling helps Greg out more than Mike because the conduct that she's alleging with Greg is that it's more recent conduct. So, Brad, to go to your point about like timing, the way that this would come in is exactly what Omar said. It would be offered as like impeachment evidence, but it would be also considered character evidence, which you can't just say someone lied then and now they lied before and now they're a liar now, unless it meets like very specific criteria. And
Right.
so with this judgment in hand, they like there's like 5 hoops to jump through. There's like so with this judgment in hand, they have like 4 of the hoops jumped through. One of those hoops is okay, even if it does meet an exception, is it still so prejudicial to the case that I shouldn't allow it in? And I can see in Greg's case, the judge being like, no, it's so close in time that like what the allegations that you're making now for this renewal are like happened during this time you were also found guilty of or liable for lying and filing frivolous lawsuit. Helps Mike out less because his actually no, if it's a renewal, then on the renewal it'll help Mike out just as much as it helps Greg for the exact same reasons. But if Mike wanted to charge his original petition, it wouldn't help him out as much because I think he could make the argument and I would likely come in, but I think there is a good argument to say this is stale. Like we're talking about 2018. She wasn't a liar in 2018 just because she lied in 2022 to 2025.
There's compelling facts in Mike's case that represent a pattern of behavior. Maybe it manifested 10 years ago, but it's continued and persisted in 2024. That you can now go back and say that, look, she's done this to other people. This was kind of her pattern. Fake a pregnancy, extort a relationship, lie under oath because it's going to get some kind of coercive control over the man. And it's happened on at least 2 other occasions that we can confirm. It may help Mike insofar as it proves a pattern. Not so much that it's propensity evidence, but it's a pattern of behavior that leads to a similar common scheme or plan that she's perpetrating on these men.
Is the fact that they were listed as witnesses in Clayton's case useful at all, or is that irrelevant?
Yeah, I mean, not really. They didn't testify.
If they actually testified, it would be.
Yeah.
It just shows that they're associated to her by their relationship.
Right.
Yeah. It gives the judge more of a reassurance that this is credible evidence. Because at the end of the day, all the rules of evidence are about is making sure that the best, most credible evidence is used. That's why hearsay isn't allowed, because I want to hear from the person who said it themselves.
It's such a bummer they didn't have time to testify in June.
2 hours is ludicrous.
Yeah.
Jesus.
And it was supposed to be shorter than that.
Yeah, like Schnuzzy, you asked me, like, what would I do different than when
they expanded it back in February. So
it was like, there's nothing he could have done. Like, he did, like, everything, it was like a race. He's like talking real fast.
Mhm.
They're trying to get everything in. They got this 2-hour limits, and then it was just over. It's like, well, fuck.
Yeah.
He said, "Okay, this will be awkward."
Wouldn't had to cook. I mean,
I don't know
So
what
he
else he could have done in that time frame. It was just Jesus.
Oh man, I cannot believe how badly Jingers got absolutely dogged on. I would quit. I would quit.
I mean, his time management was clearly not the best.
Yeah.
And he was nervous. He was like shaking. His hands were shaking. Holding.
I mean,
his
I get
pen.
nerves. I can't fault him for being nervous.
Yeah, me neither.
I can't, but I'm gonna make fun of it. Sorry.
Fuck yeah.
Like
His penis shriveled up like David versus Goliath in that statue.
And he wasted time at the beginning.
Like how Michelangelo constructed the statue of David to be like shrunken penis because he was fearful of Goliath. That was Gingerbread. That was our boy
the
Gingerbread.
David
You know,
The David.
in
you can be
Florence?
nervous, but I
In
think
Florence.
there's this aspect of discipline and preparedness that I think he did not display as well.
Yeah, he was
as,
out of his depth.
Woodennick did.
Yeah.
I mean,
Wouldn't it
you know,
came all about facts, and he had the facts on his side, and he wasn't like having to make these outlandish arguments, and he wasn't wasting his time on social media and like getting into these YouTube comment fights with other people. Gingerbread was just a clown the entire. I'd be shocked if this guy doesn't lose his license or is penalized somehow to the point where it just forces him into retirement. I mean,
Now, if he
after a
lost his
showing like
license
that,
in Arizona, do you
pregnancy
think
faker.
what?
what?
Do it again.
Douche canoe and pregnancy faker.
I mean, he's not wrong.
Literally, he had three judges tell him.
English, motherfucker, do you speak it?
This will
get awkward.
Yes.
Who the fuck are you to put me on trial? I've never even met you.
Boy.
Do you think that if he loses his license in Arizona, that the state of California
Oh, for sure. Yeah.
would do anything? Okay, yeah. They'd follow suit.
If they're aware of what's going on Arizona, he has to report it anyway. He has to self-report it. If he doesn't self-report that he's under investigation in Arizona, he could get in trouble.
Interesting.
But if he's
Well,
disciplined
I
in
can tell you
Arizona,
he 100% has not self-reported that.
well, then he's going to have to answer some real hard questions.
That's
And if he
awkward.
actually gets disciplined in Arizona, then I can't imagine that California's just going to leave it alone. I think that they're going to probably mirror whatever punishment comes down in Arizona and California, maybe even a little bit harsher because, California's got harsher rules, I think, when it comes to that kind of stuff.
And they'll run their own investigation too.
They will. Oh, they will. They may be already doing it to the extent that they're aware of what's going on.
Yeah, see, this is if you're gonna take I think the good lesson for me to learn as a lawyer here is and I don't think I would ever take a celebrity case, but if I was ever lucky or unlucky enough to be in that position, I would just really have to be on my P's and Q's. I would realize that now, and especially if I wanted to play in the PR world, I would really have to step up my fucking game.
You just have to. It's a different game, man. You're playing chess at a different level. It's 4D chess. It's
What do
not
you-
just you and opposing counsel and the judge. It's public perception. And if you're not big boy enough to let the public say what they're going to say without it affecting your legal strategy, then you have no business taking a high profile case.
Would you think that him being a solo practicing lawyer negatively affect him in that regard and not have anyone to bounce anything off of or be able to, if I'm going to take the briefings, you handle PR or things like that?
100%. If
he should have a mentor though. That's not shitty. He should have someone that he could go and talk to about this.
He was living in an echo chamber where his legal arguments were genius. And the outside world was like, what the fuck is this guy talking about? And he didn't have anybody telling him that, hey, bro, you need to seriously reconsider what you're saying.
That's a good contrast because if you remember the cost structure documents from Woodnick, he specifically had billable
Yeah.
hours in there where Woodnick went and got consultations from other attorneys about specific issues in this case.
There's cases that I have, like I consult with other attorneys all the time. Like I never just like if I'm confused about something or unsure, like I'll at the very least bounce my arguments off of other attorneys to make sure that I'm not crazy.
I call them
Like I did it in
sanity
this
checks.
case even.
Yeah, I call them sanity checks. I'm like, am I crazy about this?
Right.
Sometimes sometimes I'm wrong. But I definitely think, yeah, having your wife as your paralegal when, that's not gonna give you any added counsel.
Is his wife his paralegal?
Yes.
Yeah.
Eee.
At least she
And-
used to be. I don't know if she is currently.
Hmm.
And where it's really hurting him is definitely hurt him with this appeal. But in the bar investigation, he almost seems opposed to even hiring his own representation. And a
Yeah.
lawyer who has represents himself has a fool for a client.
Especially attorneys because,
I cannot imagine him hiring someone. I feel like he would just think that he could do everything better.
well, that is the danger of having the ego like David Gingerbread. If you're trying to overcompensate for an uncircumcised little penis, then you might make mistakes such as trying to represent yourself to the Arizona State Bar, trying to argue that you are somehow not unethical in this case. He's got a lot of issues, man.
Yeah, that was a
And-
specific thing in engineering management when I was in tech. At the higher levels for individual contributors or higher level managers, you always want to be like having a coach or a mentor and also
Mhm.
being a coach and a mentor.
Mhm.
And the person that you're talking to doesn't necessarily have to be somebody with more experience than you or whatever. It can be orthogonal. It can be, sort of sideways. It just needs to be somebody who can help you, with the
Think through
problems
the
you're
issues.
facing,
Yeah.
brainstorming with some coaching, reframing a problem so you can look at it in a different way. And if you don't do this as a manager in a high functioning, high productivity organization, you will have problems.
Yep.
I have a good example is when he was threatening to sue Lauren over copyright. I did some free legal research for Lauren, and I realized I don't know enough, and so I DM'd a legal influencer who specializes in copyright, and I was like, "Hey, man, I just threw it all on the table, I'm a fucking idiot. Can you help me? My friend needs help." And we got on a Zoom with him the next day, and he walked us through everything. That's how you should handle a situation, in my opinion, where you're not sure and there's a lot on the line.
Yes.
Yeah. I guess he technically still has however many years to sue me, but if he's that pressed over $13, come on. I don't even know what to say to that, man. He's saying because I demonetized the stream, I did that in real time. And he's like, well, Lauren, benefited financially via super chats and all this other stuff. And it's like, first of all, super chats are not for, that's not like they gave me money when they're sending you a super chat saying happy birthday. It's not like you're making money. I'm making money off of your video. In fact, no one wants to hear you talk. And then also the Patreon money that he said I was making something like $8 a month from that. Yeah. So I was just really he thinks that's a flex, but you're gonna fight. First of all, you're gonna blow up any chance you have of a passive or not even passive income, but a source of income. If you decide not to continue practicing law, and second, you're going to eventually lose money, even if you want attorney's fees for me for something. I can't fucking pay that. So you're gonna get it what over a span of I don't even know how much time, and it's gonna come in a little bit at a time. It's not gonna be good for you. I don't know what you think you're gonna do with that. Not only I just think he was wrong.
He's
So
just a
not
big
only
fucking bully. He's a little bitch and a big fucking bully.
That's the problem with that guy is he just has to have something to complain about or something he can do a tweet about. It doesn't have to be accurate. He doesn't have to get into the details.
Yeah.
Real attention to detail in terms of, science, engineering, lawfare, whatever, requires you get into the context and the details. And what he would do is this thing like, oh, well, Lauren and Dave and Megan Fox are just out here making all this money. And it's like, what are you even talking about?
Ad revenue is not that lucrative. It's not.
It's like
he got real jealous and started his own YouTube channel that nobody watches.
To him, he doesn't want to actually have an honest intellectual discussion about the facts or the details or the quantitative details. He just needs some rhetoric that he can put on the page. And then he's done.
What do you think the odds are that he's live streaming right now?
No.
He's not.
No.
He's sitting in a shower with a bar of Irish Springs crying.
With the stripper.
What?
He's probably at an Arizona, an ASU.
He's allegedly.
Is it that 5-in-1 Irish Spring? Because I hear that really pulls off all the soap scum.
He's getting one of them air dances because she doesn't want to grind on him.
Get awkward. Yeah, I remember that girl. She was a hoe.
Where did you get that clip of my dad? Hang on, let me read. I have like 4 of these. 1 second. Stir Crazy, thank you for the 5. Just because you're awesome. No, you're awesome. Just Ricardo, thank you for the 2. Totally. Hello, Lauren and Omar and guests. I'm new. Sorry. Hi, Ricardo. Thank you.
What's up, Ricardo?
Tammy Lynn, thank you for the 10. Thank you, Lauren, not only for your content but for being you. You're welcome. Sorry for screaming in your ears. Thank you, Tammy. Cat Lady Ballerina, thank you for the 5. This entire stream is just full on ding dong hate, and I'm here for it. Thank you. Not true. We also talked about. Well, I guess that's it. Yeah.
Lauren's mom.
My mom's asleep. You leave her alone.
I mean, I don't want to hate the guy. I want him to get help and apologize and stop being rude. That's what I want for that guy. But I don't think that's going to happen.
It's also been a long time coming where we've been like going back and forth with this guy for months. And he's always said, just wait till the appellate decision comes out. And now it's out. And now we're dunking on him a little bit. This is what he gets. I don't know what to tell him, man.
He actually, to use my favorite word, literally asked for it.
He did.
Right.
All of this shit. All of this shit.
I remember when he posted something on Twitter that was like, send hate. And I was like, you realize you can't then complain about that later, right? You just said like, send hate. Here's my phone number. Or something like that. Like, it's ridiculous.
Oh, yeah.
It's kind of surreal still.
I am. I hate to run, but we just got to the hotel for our first stop on the road trip.
Just walk then.
I gotta go to bed, man.
All right, I will walk to bed for sure. But I'm definitely gonna read through this again and again and again and again.
I'm definitely gonna stream it probably next week or something. I don't know. I'll find something to do with it. Once again, why not?
Be happy to dunk on him again twice on Sundays.
I mean, it might make some cheap toilet paper if you use your office printer or something.
Well,
Gingrich should frame this decision as like, a reminder to like what he doesn't ever want to do again.
Print it out on cardstock.
Let's put this on the billboard in front of his house. Like he talked about doing to Mata with the truck or whatever.
And God's piece of shit. But that's the last thing I'll say is, Lauren, when I have my friend hat on, I think you could absolutely beat him in a copyright case. As your friend lawyer, I would not advise you to do that. But dude,
I was like fully ready to blow that shit up for a minute. I was like, all right, how do I get that ball rolling?
It's like talk Lauren off the edge.
It's like, hey Lauren, why don't you slow your roll a little bit, man? It's such a bad
multiple times.
Trying to fall on the sword and all, I get it, but still.
I wasn't trying to fall on the sword. I was like, I'm gonna sue this asshole myself.
I know what you meant. I'm just saying, man.
I'm not falling on anyone's sword, brother. I'm not trying to get accidentally pregnant with twins.
Well, I am.
It doesn't fall in your mouth because that'll do it.
If you went in a red turtleneck, if you went in there with a red turtleneck and a wig on to like every court hearing with him for that, I would absolutely be there for it.
I wouldn't have to purchase a new outfit for court, I guess, if I did that.
Right. Imagine if you just show up there and like don't laugh at all.
No, absolutely not.
I have to get some
All right.
glue or something because that thing falls off a lot.
Night, guys.
No, guys,
Bye.
See you, Patrick.
See you later, Patrick.
I gotta go to bed. It's my turn to go too.
All right, Lauren. Well, don't run out of the house naked, as they say.
Okay, we keep having this conversation. That's just not like on, it's not like on my list of like bedtime checklist. Go outside without clothes on. It's not.
I'm on gummies, not bath salts, bitch.
Yeah, right.
Or the woman.
My problem is I don't know if I hit the end button. Does that close you guys out too? Though that's the problem.
I don't fucking know. I've never done this before.
Well, I don't want it to abruptly end your streams.
Oh well, whenever we end,
Let's do it.
I'm gonna be done.
Yeah.
Oh,
So
okay.
it's cool.
Go
We're
nuclear.
ending to. We're all finishing at the same time.
Oh, isn't that magical?
Isn't that
I think I saw that on Pornhub once.
Something.
So Cindy, some
Oh.
people are probably trying to fall asleep to this shit. They just ruined their night. Cindy
Making it
Landis, thank you for the 5. I love seeing you all together again. I wish Dave and Meg were on too. Yeah, Dave. So Dave did his stream, and then I think he probably had August. So, and then also Megan. I know she's
Megan is
been in the
aware of the
hospital.
situation.
Yeah,
Megan's in the hospital, if
Yeah.
not for
Is she?
her, but
Child.
for her daughter's having problems.
Oh.
She's aware of the ruling.
Hmm.
Yeah.
Well, we'll get the whole gang back together at some point.
It'd be fun to do a big stream.
Yeah, we should. Why the fuck not?
It'll be so chaotic.
I'm down for it. I'm bringing the soundboard and everything.
The voices and everything.
And the voices.
Did Lauren cut her hair during the stream? Yeah, clean off.
Totally.
I do have
On both ends.
something to plug. Keep your eyes on Reality Steve tomorrow.
Oh yeah, that's right.
Oh,
What
nice.
is he doing?
I can't say, but
Is
he's
it
got
related
something.
to this stream?
It
Brandon, or
is
no?
kind of related to this dream.
Ooh,
The
nice.
subject matter.
Can't wait. Can't wait.
He's gonna read it in the nude.
No.
Well, you just told us you can't say, so obviously that's what's happening, and you're lying about it.
Out of all the people, I somehow offended Hey Rob and nobody else.
Wait, you offended Hey Rob?
He said, Omar, come on. It's like, what did I even say? What did I say? I don't know what I even said.
It's his birthday, yeah?
Yes.
Happy birthday, Rob.
Nobody can get more righteously indignant about this case than Reality Steve. So I look forward to whatever he's doing.
We'll be doing not I don't know what time he's going on. I won't do it at the same time as him, obviously, but we'll go over the hearing in Greg's case, the video that's on Schnitzel Ninja's channel. We'll go over that. I'll go over that tomorrow night too.
And there's gonna be another one coming out tomorrow. It
That's
just
right. Yeah,
got pushed because of today.
it was Omar's fault.
Totally.
Mhm. All right, I got a dip.
Thanks for having us.
Bye,
All right.
everyone.
Everybody, you guys take care. Love you all.
Woo!
Oh yeah.